Ah, there is still medical admission going on. All right. Yes. Huh? Huh.
Lordship. Fresh contempt, Your Lordship, against an order in COMCA, Your Lordship.
Contempt
Yes, Your Lordship.
tomorrow.
Lordship. Posted the matter of after 4 weeks by the 30th of August, Your Lordship. But the matter is not listed, Your Lordship.
It will come up after. What is the urgency?
Your Lordship, the challenge in the GMS number 57.
No, that's correct. So what is the urgency? Like it should be listed tomorrow only.
Process has
If we are going to reopen, don't have this feeling that the High Court is going to be closed forever. We will reopen after 5 days. It will be taken up thereafter. What is it? It will come up after that.
Yeah, please, Lordship. Matter number 49, Lordship.
You want to withdraw?
Yes, Lordship. I will file a memo.
49. Item 49. What is? Learned counsel for the petitioner has filed a memo seeking leave of this court to withdraw the appeal on the ground that why do you stand in between the lawyer and this thing? So it has been settled.
Sorry.
On the ground that the dispute has been amicably resolved between the parties. The aforesaid memo is taken on record. No, has filed a memo, you write in the beginning. Memo is taken on record. In the result, appeal is dismissed as withdrawn. Yes.
Lord, may I request, my lord? May I
Yes.
request, my lord? These two writ petitions, my lord, they have not come up for hearing, my lord. No date is given in this matter.
No
So,
date.
therefore, I am.
No. What date?
After
Hearing is
vacation.
final hearing.
No, my lord, for admission only.
Ah.
Court commissioner submitted report, my lord. Thereafter, yes. No, I am mentioning, my lord.
Mentioning. Yes.
Writ petition, my lord, in this
When did you file the writ petition? For what purpose you want listing, madam?
2020, my lord. Already
so it is pending 3 years. So what is the urgency today when the court is about to close tomorrow for vacation? Tell us.
No, after vacation.
What do you want?
Notice already issued.
So why do you ask, brother?
For admission, my lord. Any day after vacation.
2nd November.
Obliged.
Lordship, kind permission, my lord. May I make a request, my lord? Online, my lord.
1910.
Subject Lordship, kind permission, my lord. May I make a...
You don't want us to pronounce the judgment, right?
Sorry, my lord. I want to make a mention, my lord.
Huh?
I want to
Yes.
make...
Additional Advocate General is waiting with a broad smile on his face. So you are preventing us from delivering the judgment. What do you want to say?
My lord, I would like to move a lunch motion, my lord, in a proposed writ appeal, and I'm going to file it now.
Tomorrow it will come up. What is happening? Your house is being demolished. Somebody is being sentenced to death today at 4:30. What is hanged being dead? What is
tomorrow may be given. Well, tomorrow may be given. Well, tomorrow.
Tomorrow. Yes.
Okay.
You first file it, mister. Because our experience has been people do not file and make a mention.
Now itself I'm filing, my lord. Lord, obliged.
No, it is subject to filing. If it is not filed by 12 o'clock, it won't be listed, mister. That are clear instructions to the office, madam. What's your name, mister?
Ram Sharan Sharma, my lord.
Ram Sharan. If Mr. Sharma does not file the writ appeal by 12 o'clock, it should not be listed tomorrow.
Obliged.
Right? We have given instructions.
Very well, my lord. Obliged.
We have issued directions in para 11 and 12 and 13, and with the aforesaid directions, the writ appeals are disposed of. So for you, it is expected, no? You told what is. See the order. Yes. Next. What is it? In view of preceding analysis, we do not find any merit in this petition. The same failed and are hereby dismissed. The writ appeals are allowed. This is Mr. 22A.
Yes.
You should, madam. Henceforth, you give it so that no time is wasted. We have to sign it. We can sign it before also, each page.
Right.
Sign. Somewhere here also date has to be mentioned. Shall I mention? Huh? For the aforementioned reasons, impugned order dated 29/8/2022 passed by Union of India is hereby quashed. Liberty is reserved to parties to take recourse to such remedy as may be available to them in law. The dispute is between the entities owned and controlled by state of Telangana and state of Andhra Pradesh. In the facts of the case, in our opinion, it is eminently desirable that the dispute between the parties is resolved, preferably through mediation. We hope and trust that state of Telangana and its distribution companies and state of Andhra Pradesh and its generating companies shall make an earnest endeavor to sort out the dispute between them through mediation. Accordingly, the writ petitions are disposed of.
Grateful to your lordships. Lord, my original
Original note. Huh? So you return it to them and this return and obtain. It will be given to you within half an hour, Mr. Please, you take her,
Yes.
take his number.
I'll be there, my lord. I'll
So
Okay.
your file will be returned. This will be signed later. They want the copy, no, they won't be shown. This is what I was telling her, that you should get the signatures henceforth, because you will not give them until unless it is signed. So it will be not available to them till evening. This could have been done earlier. That's what we are telling. Henceforth, otherwise this time could be saved, no?
Yes, madam.
And they won't hand over the copy to you. Why shouldn't you not hand over once it is signed? Huh? Yes, madam, you can give it to them for
With copy.
You don't give, that's why we are signing. Now itself, now it can be given.
ఇక్కడ సైన్ అయిన కాపీ ఉంది. సైన్ కాపీ. Okay.
Inescapable. I'm sure that we are concerned with the legal issue. It can have one wisdom also.
Yesterday matter actually postal and with the
Huh?
rate appeal number 1012 up to 23 also. Yesterday matter
101.
1012 up to 23. Postal and
List for analogous. List for analogous hearing along with WA number 1012/2023. We'll issue notice. Because see, it has to be clarified. Yes, you are pair for respondent.
Yes, correct.
You have not filed an appeal.
We are, since we have not received the Millard copy, Millard, we are also getting.
Then this, supposing if you file appeal next year and then so stay will operate, it can't be. This is their grievance that I mean, you will not file an appeal and there will be a stay. You file an appeal within Mr.
Before the appellate authority, Lord, we have not received the certificate of the government will not accept Millard, they cannot have the.
No. Mr. You undertake to file it within 2 weeks. That is understandable, but it can't be that you will not file an appeal and the stay will operate. Please understand. Now you can't file an appeal because the single judge had given a period of 30 days. So, and stay cannot operate indefinitely. It's convenient for you not to file an appeal and that's the grievance. Otherwise, who would file an appeal?
Instead of granting 10 days time, the learned judge granted 30 days time, and that is the agreement.
No.
We'll file Millard immediately.
What is your grievance? Not filing.
They cannot
Not filing up.
And they cannot Millard, declare that Millard to the learned judge, the learned
No.
ought to have granted 10 days instead of he has granted that cannot be ground.
No, that can't be ground. But we no. If you undertake to file, that's it. That's what we are saying, Mister. Nothing else. We will dispose of this matter in the view of statement made by him that he will file an appeal by 3/11. That's it. No interference. We are not interfering with the order. You are filing an appeal within the period of 1 month, correct? No. No, but how they have filed an appeal? So, but you can also file with dispense. No, Mister. As we have read, their grievance is that's it. So that 30 days time has been given. There is nothing to interfere for. Like so, if they don't file, we will say that it will stand. It will not operate beyond 30 days. Huh? No. They will have to file an application for a stay. We will modify the order till application for stay is decided. They will file an appeal up to 311 within the time limit. There, along with an application, the stay application shall be taken up for consideration, and till it is decided, the order will operate. Correct. This is the limited grievance. Yes, Mister. So you will file the appeal. This intra-court appeal. Mark the presence with.
Sorry, my lord,
Huh?
I could not receive the judgment.
Huh?
I couldn't receive your lordship judgment, my lords. I delayed. My lords, this is only
Delay?
to express the bar.
case?
Item 2.2, pronouncement, my lords. We
Huh?
are quite grateful, my lord, for the quick judgment rendered in the issues which have been kept pending, my lords, for a longer period. The bar acknowledges, my lords, the early
No,
judgment.
we have done our duty, not
Yes,
like
but
it.
the issue has been pending for a long time, my lord. We are grateful for that.
Thank
Obliged.
Yes.
Obliged.
A copy today, certified copy today. Today. No, today. We don't keep it pending, mister. Before going home, I will sign it. So why there is no reason? I will sign it at 1:30, between 1:30 to 2:30. So it should, there is no reason why it should be kept pending. Yes.
Your Lordship, item number 25 is the connected.
Ah,
Your Lordship, item 16 and 25.
corrected. Yes. What? So, so we will take both the cases together. Yes, tell what is it?
Your Lordship, I can.
No, but Mr. C, this thing is simple, right? Can you prevent him from coming to mosque and offering prayer?
I cannot prevent him.
That's it.
My submission is that, my lord, only Lordship may kindly see the order passed by the learned single judge.
What is the portion of which you are
That
aggrieved?
is, I am para 8, my lord. Para 6 and 8 I will read, my lord.
64 to
Today, when the
Block
matter
five.
is taken up for consideration, may I read, my lord, page 13,
para 8, no?
para 6.
6.
Today, when the matter is taken up for consideration, Mr. Abu Akram Learned is standing counsel, appearing for respondent 2 and 3, placed
Walk back.
before this court the proceedings dated 6/7/23, wherein one Janab Muhammad Sufyan Ali Shah, late Muhammad Mujahid Ali Shah, was appointed as Mutawalli under section 63 of the Act 1995 in respect of the WAF institution in question. That Muhammad Sufyan Ali Shah is the appellant before your lordship, but he is not implicated. Your lordship may kindly see that para 8. In so far as the claim of offering prayer by the petitioner, my lord, being the devotee of the subject institution is concerned, the same cannot be restricted, obstructed by the respondent authorities in view of the section 64(2) of the 1995 Act. I am concerned only in view of the portion that sentence.
No, Mr. As we are understand, like, I mean, you know better, but mosque is a place open to all. Any devotee can go and offer prayer.
I do
How
agree.
can you, I mean, because he is not Mutawalli, he will not be allowed entry.
I do
Can
not
you do it.
I do not have any objection.
Then?
I am having only objection this sentence, my lord, in view of the section 64.
Whatever, in case you are not opposing his entry, there is nothing.
No, that is the rights will change, my lord. Right for a moment, 64, your lordship may kindly see. 64, my lord, section 64 of the WAF Act. Totally devotee, he will not be a devotee if under section 64, he will get more right. It will amount to interfering in the management also. Appellant management, my lord. In your lordship, for a moment, 64 kindly see.
Heard on the question of admission, appeal is Testing, like, they don't want him to enter the mosque house. Because he is no longer Muslim. See, no. He was earlier in the problem. He did not have personal right. You don't have. You can go earlier to devotee. Yes. And whatever rights he has under being the ex-mutually. That's what say personal rights if any. He will be nobody can. Yes.
Wait, please. That this appeal is against an interim order.
So you can
Normally,
seek vacation.
But we filed a vacancy petition, right? Due to
Ah.
paucity of time, the learned single judge is not in a position because of the workload. Right? Learned single judge is not able to take up these matters. Sorry to say that. But I'm only pointing out
The vacate stay petition.
infirmities in the order. There are only two glaring legal infirmities in the order. That's why kindly I'll say without going into merits, I'll just indicate what are the glaring infirmities in the order.
They see, the question is like, if we start entertaining vacate stay petition in the garb of writ appeal, there will be no end. No end.
I'm conscious of the fact, Millet.
Yes.
But this particular order, Millet, there is expressly two glaring illegalities that learned judge committed in passing this order. One is, Millet, Dashma, can you see the interim application and the order passed? The interim relief sought, kindly see page 12, Millet, for a moment. Relief sought in IA and the main writ also. It only speaks of dispossession. And learned single judge, Millet, passes an order that there shall be an, I'll read the second paragraph of the order, Millet. There shall be an interim direction to respondents 2 to 4 to maintain status quo with regard to revenue increase in respect of land in survey number so and so, situated in so and so. This was never asked for. Learned single judge grants the relief much more than what was asked for. Another interesting aspect in this case is that there was a tenancy dispute between the parties. A learned single judge, another learned single judge, exercising the jurisdiction, revisional jurisdiction of this court, declared our title under 38E of the Tenancy Act. Our title is declared there. Now, without questioning that order has attained finality. Now, this writ is entertained to stop the consequential action to be taken up by the revenue authorities pursuant to order passed by this court.
They are not to interfere with the possession except in accordance with law.
Yes, that I do agree with.
For
that I have to file an application under section 32, which I would be taking course.
Huh?
But when the learned judge proceeded to prevent revenue authorities from making necessary entries in the revenue record, conferring
In your affidavit, in the writ affidavit, if you go through,
yes,
there are a lot of complicated issues on title.
they are all decided by the learned single judge.
As far as the status quo is concerned, it can be inferred as in entirety.
Yes, ma'am. That's
What happens if only it is confined to the disposition, even to the extent of incorporating names, there is a status quo.
Things have to take place pursuant to order passed by another learned single judge. Well, that order you also should find at page 50. That was in fact pleaded by the petitioner himself. He suffered an order in 2 revision petitions.
Why he can't vacate, file vacating
You have to file a status quo to
Vacate
file an
ticket.
application to vacate status quo.
We filed the application for vacate state. It is pending. Well, may I just request my lords to kindly
When?
direct the learned single judge to take up the vacate petition.
Huh?
That's why dispose it off by directing the learned single judge to take up the
Yeah,
vacate
not directing, we will request him. This we can't entertain a writ appeal against an interim order.
It would be only a request.
Ah.
Let me just-
1923, when have you filed vacate petition?
That was sometime in September.
Huh?
October, I told.
13th October?
Yes.
After 6 weeks, you have filed and saying no time.
After we received a copy of the order, we learnt about it and then moved the court.
No, but 1st of September, the order was
Yes,
passed.
sir. We received
You
a
did not
copy of
know
the order.
about 6 weeks.
We received a copy of the order, then we moved the application. This is because the learned single judge, by entertaining the request, is practically sitting in judgment over the order passed in parallel jurisdiction by another learned single judge.
This is not the way, mister. Like you will, supposing if an ex parte order is passed by us, you will go to Supreme Court and argue that division bench without hearing.
Vacate state petition to be disposed of.
That's what. We can't set up a wrong precedent by entertaining your appeal.
Concepts are not entertained.
This intra-court appeal has been filed against an ad interim order dated 1st with etc. allowed heard on IA number.
Nagesh Reddy.
18.
For the respondent.
Yes. Ah. Yes.
Not happy for the respondent. Smart.
Ah.
We filed a KBT in the smart not as respondent. We're yet to be served paper. We filed.
When have you filed? He has to argue on admission first. When have you filed the caveat? Huh? No, no, it has been, it says heard according to, it's, no, you said that without hearing it has been passed. No, this order says it heard, mister. So what, many petition, they are not registered and we decide, so you will take advantage that, no, it has not even registered, so obviously court did not hear me. When there is an objection, mister, we are giving you an example, right? There is an objection here, the procedure is registry, it does not number the petition. They are listed, we hear you and decide it, right? Or dismiss it or something. So you will say that I was only heard on maintainability, not on merits. Therefore, this is new ground we have learned now, that therefore the order is bad in law, that because I was never heard on maintainability. Can you argue like this? No. I mean that the court could not have passed an order on merits. What do you say? This is appeal. This is appealable. What about the section 18? A order passed by the DRT. So it has been dismissed. So this order is appealable under 18. No, order is what? Let's see what is an order. Surface Act. Surface Act. Surface. Is maintained. No. To go for appeal. That's what. That's why he has not answered. He knows what is the query. Yes, section 18, please read.
The tribunal within 30 days from the date of the receipt of the order.
Order is an order.
But this is an order passed on the administrative side. It is not a speaking order on merits after giving notice of.
Administrative side means what?
Let's say review application is filed.
No. See, Mr. This is, you have been heard.
But heard.
You file all whatever grounds, administrative side, whatever side. Like this, not like if I pass orders on a file sitting in my chamber and sign in the order sheet, that will be an order on the administrative side. So how this is this? I mean, we don't know it has,
We have never heard these aspects at all.
but this is an order nonetheless for the purposes of section 18.
Let's kindly consider this first. I filed a review. The scrutiny takes an objection. A simple one-line objection stating that how the review is maintainable. We resubmitted it stating that the review is maintainable as per provisions Rule 5A. I have a right to file. It's a statutory remedy available to me. Against an order passed by the DRT, I have a statutory remedy to file a review. We resubmitted that and we were heard on that only aspect only. We stated before the tribunal that the review is maintainable, it has to be registered and order has to be passed on merit after ordering notice to the other side and like considering all the aspects. So many aspects on the merits. We have never argued. The tribunal goes and decides all the aspects in a small paragraph stating that these are the aspects covered in the main order without hearing us, without hearing at all. Generally, what happens when a appeal is returned or a second session application is returned, for scrutiny, the scope of scrutiny is whether there is an order, I have filed, whether it is filed as per the procedure, whether I have paid the court fees. These are the only things which the scrutiny has to notice while registering my review application. The review application is not registered and an order is passed on by it. My remedy to appeal,
where is this one? Where is the averment that it is an administrative side and not a quasi judicial order?
It's as stated in my affidavit, not exactly
that you have not been opportunity of hearing has not been given to you.
Yes, my lord, I have stated so.
This order says, Mr. There has to be a presumption of correctness of the order. It can't be like we say that with consent of the parties heard. So you will say I never gave consent. So you this can't we say here heard learned counsel for parties. You will come and go before higher forum and say I was never heard.
This is not
this is a correctness. There has to be a presumption of correctness of an order made by an authority.
I completely agree with that. I was heard on maintainability only. Nothing else.
Whatever. So you can urge that ground in appeal.
Perhaps may kindly say I have stated in the writ affidavit also. But unless it is registered, but it's not a discretionary relief which the tribunal can decide on the maintainability and go into the merits. The tribunal
it's an order deciding your review petition. Correct. It's an order deciding your review petition incorrectly according to you, wrongly.
Not even registered. Kindly say. If an application is filed, it has to be registered first. Passing any order.
Argument can be good that we learn everything new every day. So today is that if it is listed for orders of the court, we must first direct registration by the office and then decide. Otherwise, counsel can say that it was only for orders on the court. I was heard on maintainability. Court could not have decided on merits.
Exactly. Yes. Exactly. But if I file an application, even a suit, it is rejected. Kindly similar to the words used, it is rejected, not decided also. The order says it is not maintainable and it is rejected. Kindly similar para 3 of the order. The case has been discussed in para so and so 7 to 12 of the order dated 31/7/23, summarily taking relevant issues, and there appears no mistake or error apparent on the face of record as per Rule 5 of the DRT Procedures 1993. When there is no mistake or error on the face of record, the tribunal has no jurisdiction to entertain the review application. Hence, the present review application is not maintainable. The maintainability, it is passed, the tribunal has passed an order stating that it is not at all maintainable. My respectful submission is a review is maintainable against any order of the DRT. There is a procedure required and it's a statutory remedy available to me. A statutory remedy cannot be curtailed by stating that no, there are no merits at all and we are rejecting your application. The tribunal will consider it, register and consider, and then if the orders are passed on merits, definitely section 18 is available to me. I can go and appeal. In the cases where it is not at all heard, and on the stage of registering itself, an order is passed. We have
no, Mr. C. All right.
But that is my responsibility.
Fine. That's it. Anything else?
Nothing, my lord.
Right.
My only prayer is
This,
the tribunal may be directed to, my lord, decide the review application on merits, my lord.
in this writ petition, comma, referred under Article 226 of the Constitution of India, the petitioner has assailed the validity of the order dated 10/10/2023 passed by the Debt Recovery Tribunal, by which petition filed by the petitioner seeking review of the order dated 31/7/2023 passed by the Debt Recovery Tribunal, comma, has been dismissed. Yes, sir.
Yes, Your Lordship, in this case, madam, the petitioners are the employees of the
Seek instructions will issue notice. Heard on the question of admission, petition is admitted for hearing. Notice. Notice on these people, whosoever is appearing, so and so accept notice on behalf of you. Who appears for?
Respondent number 5.
I'm for the first respondent. Toon Srinivas. Yes.
For respond number 1, 2.
Two I have appeared. Yes, Srinivas Rao.
2. State you 3. 3.
5 minutes.
5. The issue state nobody appears, right? State of Telangana. Issue notice to respondent number 4.
It's a formal participant. Support.
Requested for the petition, Your Lord. Please, Your Lord. My Lord, the
Heard on IA number 1 of 2023 for the reasons assigned in the application, duly supported by an affidavit. The requirement of filing the certified copy of the order is dispensed within the result. IA 1 of 2023 is allowed. Heard. Yes.
My Lord, the tenant has earlier approached questioning section 14 orders of the CMM before this honorable court. And my Lord, this honorable court passed the order. Your Lordship may kindly see, my Lord, at page 171. Operator posted 175. 175, my Lord, directing the tenant to hand over the premises in favor of the bank, that is the petitioner before your Lordship. Thereafter, what the tenant done is, my Lord, tenant has handed over it to the present respondent before your Lordship, who are the mortgagors, who are the owners of the property. My Lord, with great difficulty, my Lord, I could get a portion of the property, my Lord, handed over to me. Rest of the portion not handed over to me. Then, my Lord, now the present respondents, the mortgagors, have gone before the DRT once again by filing a separate my Lord, SCA and sought for a stay of dispossession. I placed before DRT by filing a counter, my Lord, the order of this honorable court, whereby, my Lord, the entire premises have to be handed over to me. DRT, without referring to the order of this honorable court, now granted stay in favor of the present respondent before Lordship.
Learned senior counsel for the petitioner submits that the order dated what the suspension?
Suspension, my Lord, now the tribunal has passed a stay of dispossession of the
Without hearing, we can't this thing. That's why without hearing him, I mean, supposing we stay the order, your petition is allowed. You will dispossess them and then what happens?
So, my Lord, in fact, the possession to me has already been directed by this honorable court in the order dated 26/7/2023.
No, but correct, but
and the tenant, my Lord,
will appreciate you. This will granting a stay will amount to allowing the writ petition.
And we filed for the sake of information to the honorable court, my Lord, already we filed a contempt case against, my Lord, this tenant and also this borrower. So that is,
you serve them as soon as possible. We can give the date immediately after vacation, 30th, 31st.
I will serve it.
30 personal notice, proof of service list on 31st of.
Please,
This is the. You are ready to argue finally, right?
Yesterday,
yes, no, go ahead.
Yesterday,
Very good.
that is arising out of the common.
Lighter, this is another day. Yesterday has gone. We did you even bother how long we sat?
Yes.
Did you even bother to know how long?
I was bad communicator, maybe.
No, we had to sit till 5:35 to complete the order. And you went away.
Yes, that order may be extended to my writ petition, which is arising out of the same common order.
We will, of course, that order we will pass. But this is not the way to assist the court. That's the only thing, Mr. Ramna. We are trying to
Arising
tell
out
you.
of the same order, common order, my lord, and
No.
anxiety, my lord. Because
Whenever,
the appellate insisting that
One
both
minute.
are ready, my lord.
1 minute. Let us not discuss a
Yes.
case which is not on the board.
Because
What we
I'm-
only telling that this is not the way to assist. Whenever the facts are, it is your duty to place the facts in a chronological sequence and give a synopsis to the
Yes.
court. Ask your colleagues to work hard. Let them roam around. The your juniors should do the homework. That's what we are saying.
Yes,
Nothing. We have done it. The order is over. Without your assistance, we have done it.
Yes, my lord, I hope keep blessed, but
Yes.
justice will be done.
Yes.
My lord, that is, my lord, this is the Surface Act, my lord, arising out of the.
Surface
Act. My lord, at page number 21, my lord. My lord, interlocutory application which was rejected, claiming that it is maintainable
It is rejected by whom?
by the DRT, my lord.
Then appeal.
Yes, my lord.
Appeal lies before under section
My lord,
18 where
my lord, at threshold, my lord. At threshold, my lord, because what I may be permitted to
how you argue?
bring the facts of the case, my lord.
Ah,
Because the borrower, my lord, has different three accounts, my lord. Different three accounts, Danda Cottons at Sumangal and Sai, my lord, Vijay Sai accounts, my lord. Because the separate three accounts are separate, having separate entity and separate secured properties also extended, my lord. But bank, what happened, my lord? In the whole, my lord, it put the option, my lord. Earlier options we are not challenged, my lord. Even in the month of May and June also, we are allowed to conduct because I think that they will debit the amount to the what the secured property was extended as a loan, my lord, as a loan, my lord. But what happened, my lord, on the 10th October 2000, 10th August, my lord, they issued a 10th July, my lord, sorry. 10th July, my lord, they issued a fresh option sale notice, put the scheduled properties also for auction, my lord. Lord, when I went to the bank, my lord, because this property was already auctioned, two properties are there, my lord, for the petitioner's property, my lord. One is for 1 crore 54 lakhs, another because minus, my lord, it should be more than, not more than 1 crore 50 lakhs, so, my lord. But they bluntly refused, my lord. Hence, they conducted, go ahead, my lord, they auctioned on 27/7/2023, my lord, the property. My lord, that challenging that, my lord, I filed a present essay, my lord, along with essay, my lord, 331 of 2022. My lord, what happened, my lord? Normally, the court has granted the 30% amount to deposit for say of issuance of sale certificate and delivery of the position, my lord. Lastly, my lord, at page number, you will also be seen that, my lord. Subsequently, when I approached, my lord, the respondent, my lord,
which is the
page number 96, your lordship may have seen that, my lord. At page number 96, my lord. At page number
application
96.
under section 17(7). There is nothing. Right. It is agreed. Then we are copying and breaking. See, this thing. This declaration which yes.
Not page
Yes.
number 96, your lordship may be.
So under which provision you had filed an application? 17(7). We were looking what is 17(7). We did not find anything. What is 17(7). And it's an order passed by the debt recovery tribunal. What happens to Mr. Satyavati Tandon, 3-judge bench of Supreme Court?
Milord, what happened, Milord? The facts I may be permitted to bring the facts.
You are telling us facts only.
Milord, what happened? 96 page number, Milord.
See, but we are not stopping you. Go ahead, whatever you
Milord,
want.
96
We only
page.
asked. We
Milord,
only
I will come,
committed an error of asking you a question.
Yes,
We should
Milord,
not have done.
I will satisfy, Milord.
No. We should not have asked.
I will come to the first, Milord.
We should not have asked you a question. Go ahead. Yes.
Milord, I will come to the facts, my lord, then, my lord.
So what you have been doing, facts? You told that facts 5 minutes ago. You told I will tell facts. We are here.
My lord, subsequently, what happened, my lord, after issuance of auction notice, my lord, some amounts were debited which were earlier auctioned, my lord. At page number 96, my lord. Actually, in the place of, my lord, auction notice itself, bad, my lord, that I will fight, my lord. Because they already, my lord, auctioned the property in the month of May and July, my lord. Prior to this challenging the auction notice, they received 3 crores 89 lakhs, my lord. Even that was not added, my lord, received, my lord, by the date of auction, my lord. You will have to seen that, my lord, at page number 96, my lord. 96, my lord. That is the bank itself given, my lord. 96, my lord. My lord, the bank has given the information, my lord, that some 3 properties were auctioned, my lord. The first property is in first 11 May 2023, my lord. The remaining two properties were, my lord, auctioned in 14/6, my lord.
Who have complied with the order. This for the execution and recovery also proceeding with the recovery. You say that I have satisfied. How that will be finally issued? It is compliant. Yes. Go ahead, Mr. Please
That
go
is
ahead. We are
96
hearing. We are hearing. Don't. We will not even ask you a question. Please
Yes,
go
I
ahead.
will come, my
The
lord.
moment we will ask you, will say, I will tell facts now.
My lord, only this will be not because, my lord, sorry to me.
Yes, sir.
Because I prepared.
You are prepared, right?
Only this. No, my lord, I will satisfy your lordship, my lord. That is due. My lord, on 16/9/2023, they gave a letter, my lord, that the property was auctioned, my lord, but it was debited, my lord. Your lordship may be seen that, my lord, first one is at 31/5. Second amounts, my lord, at their whims and fancies, my lord, that amounts were, that was amount credited to the accounts, my lord, not according to the, my lord, the secured properties which is secured to the that extent loan, my lord. But as per their version itself, my lord, the accounts are outstanding at 10/7, my lord. They are shown that that is only 7 crores 7, my lord, 7 lakhs, my lord. Instead of, my lord, on the auction sale notice 10/7, my lord, it's showing that 9 crores 97 lakhs, my lord. Hence, I made an application, my lord, before the DRT, my lord, because after issuance of the public option, my lord, the bank has received more than 3 crores 30 lakhs, my lord, which were debited to the accounts. That has to be treated as a compliance of 30%, my lord. The same may be continued, my lord. I filed an application, my lord, under section 17, which shows, my lord, I made an application under section 17(7) and along with provisions of RDB Act, my lord. My lord, your lordship. Section 17(7), along with read with section 22(2), that's my lord, because wherein the my lord procedure and powers of the tribunal and the appellate tribunal, my lord, contemplates. I'm saying that I'm only asking the DRT, my lord, to treat that which the amount were debited, my lord, to the account subsequent to the issuance of the auction. That is complained and stay may be continued and essay may be heard and disposed on merits, my lord. Lord, I am permitted to read section 17 of surface, my lord. Lord, section 17 contemplates to, my lord, any measures, my lord, to the borrower or guarantor, my lord, to approach the DRT, my lord, challenging the measures, my lord. 7, my lord, says, my lord, save as otherwise provided in this act, the debts recovery tribunal shall, as far as may be, dispose the applications in accordance with the provisions of recovery of debts due to the Banks and Financial Institutions Act 1993. I'm only seeking for dispose the SA, my lord, as the others, to be treated as complaints, my lord, in the order passed in INM, my lord. Section 22, my lord,
That means we should go and tell the DRT. Stay operates, self-invited trouble.
my lord, section 22, my lord, says that procedures and powers of the tribunal, my lord. Thus, my lord,
How technically
22.
compliant?
to H, my lord.
No, this the order passed, it will remain state subject to 30%. If he has paid, he has paid it. Why this thing, an order of
But
DRT?
I just will not further proceed because that section 22 will not 2H will not any other matter which may be prescribed. But my anxiety will not be confirmed will not without deciding the essay will not because where is how bona fide is will not in entertaining my application. The DRT dismissed my will not I may permitted to read will not the IA will not at page number 21 will not. This IIR is filed with a prayer to treat the order dated 2023 as complied and continue the stay order not to issue the sale certificate in favor of the auction purchaser. The register has taken objection as to maintainability.
See,
The register has taken
11,920. It has for reporting compliance. So that instead of reporting compliance, is filing an absence.
the register has taken objection as to maintainability. Hence, the request of the learned counsel placed before me. As per the learned counsel for the petitioner, the amounts realized through auction of 3 properties towards compliance of conditional order. Through auction of the 3 properties towards the amount realized, which is debited subsequent to the auction sale notice, my lord.
Need to file an application and to DRT certificate. We will say not to sign this, like this, it will be open point to show that he is compliant. So, you should need to file with that.
The register has taken the maintainability, my lord, as took place before the DRTPO presiding officer on the bench, my lord. When he was passed orders that, my lord, the maintainability was upheld, my lord. This petition with the petition so and so prayer is not maintainable either under section so and so or section 22H the RDB Act according the IA is rejected, my lord. Hence challenging that, my lord, I am before your lordship. But your lordship, I am paying that. Your lordship will direct the DR to decide the IA as on merits, my lord. Hence, that is my prayer, my lord.
Which the problem is we can't ask you a question. I will tell facts. We are afraid. The moment we ask you a question, you will say, I will now tell facts.
No, my lord. Sorry, my lord. Sorry. Because I prepared, my lord, when I struck my lord, I cannot. That is my problem, my lord.
This section 7.7 years right. They are not maintained.
When I struck to that, my lord, I cannot continue, my lord. Because I prepared, my lord, that matter.
What section you have filed an application under section 17.7?
Yes, my lord.
What is 17.7? How does an application, the tribunal has rightly rejected that it does not lie under 17.7. What is 17.7 of SURFACE Act? See, Mr. Without what to do, without seeing the statutory provision, you file application. There was no need to file an application.
Section 22(2)H, my lord, the powers conferred on the tribunal, my lord. My lord, this is the application against measures, my lord, under section 17. The applications against the measures of
17.7 you have filed the application.
Yes,
what does 17.7 say?
Yes, my lord.
Read it.
Save as otherwise provided in this act, the debts recovery tribunal shall, as far as may be, dispose of the application in accordance with the provisions of recovery of debts due to the Banks and Financial Institutions Act 1993 and
So how does 17(7) application lie?
under the surface, my lord, any measures, my lord, only section
You have
17.
filed 17(7).
7 and along with read with section 22 of 22(2), my lord.
All right. That's it. Anything else?
My lord, under 22(2), my lord, procedures, my lord, and powers of the tribunal which was conferred under the PRT Act, my lord. Apart.
Anything else? Yes. Yes. Then how, then there is a stay. This is misconceived.
Lords, I request a week's time to file briefs and all.
He wants that the stay, the auction, no, he should be stayed, he should, and that auction amount to be considered as, he has been directed to pay. Frivolous. Yes.
Lords, I request a week's time to file a brief synopsis. My lords, may kindly have it in the first week after vacation, my lords.
List after learned counsel for the appellant prays for adjournment, list after ensuing Dasra vacation.
Obliged, my lords. Item 22 also goes along with.
Huh?
Item 22 also goes along with it, my lords. Connected CRP. 23, I'm sorry, my lords. 23 goes along with 22.
Ah, that's what we were surprised.
Obliged, my lords. Obliged, my lords.
May it please your lordship. Mr. P.C. Raghuram, senior counsel, is appearing in the matter. On last occasion, lordship had directed it to be posted.
Coming from there.
Yes,
You are looking
in
back.
another court, my lord. Just looking. Meanwhile,
We'll hear
lordship,
you after this thing. After vacation. List after ensuing Dasra vacation.
as lordship is. Much obliged.
Item 26. Yes, only
26, 20, 25, what happened? Huh? Notice. Yes. Yes.
And I passed I issued instructions in this matter as the appellate authority's regional director, office situated to Warangal, the hierarchy of the office, may I pass this? The appellate authority's regional director of municipal administration. This I issued instructions, for the Karimnagar, for the impugned order to file against appeal against the impugned order, the appellate authority office is situated at Warangal, designated as regional director of municipal administration, Telangana state.
No, this, he has. This is yesterday's matter.
My lord, I am from the petitioner.
Ah.
My lord, appellant, yesterday lordship was pleased to direct me to find out who has got power to, my lord, remove the unauthorized constructions under
Yes.
section 181 of the Act. The authorized officer, my lord, the power to, my lord, seal authorized constructions development is, my lord, section 181. 181 of the Municipal Act, my lord.
So who is the person competent?
My lord, under 181, my lord, it says it will be lawful to the local authority at any time before or after meeting, making an order of removal or destruction of any unauthorized development, construction,
Madam, this act.
to make an order. My lord, now the in the section, my lord, it says local authority. Local authority is defined as municipality. Under section 181.
Who is local authority?
Local authority is nothing but, my lord, local municipality. My lord, headed by commissioner.
Where does it say that anywhere this expression defined local authority to mean what is?
My lord, local authority has been defined. Definitions as a municipality, municipal corporation.
Where?
In the definitions, my lord. I'll just take your lordships, my lord.
Section 250. Local authority means municipal.
Section 250.
Municipality, municipal corporation. So, in addition to the commissioner, municipal corporation, who is the other officer?
Town planning officer.
No, so if an appeal lies before the regional director.
Now, for the first time, a learned friend says a regional director has been appointed who is competent to dispose of the appeal. Well, situated at Warangal. This fact I'll find out. the commissioner as well as the regional director is one and the same or not? The act,
But it's a different, he's a different authority. Why don't you file an appeal?
but the act says the.
Where is it, that notification?
This is from website, I downloaded this.
See there, my lord, section 252.
That's what he's saying. Arey, Mr.
Any person aggrieved by the notice issued by the municipality under the act, they file an appeal before the regional director within 60 days from the date of receipt of such notice. The regional direction
In bottom,
same act, 138, page 138 of the Municipalities Act.
in bottom designated.
52, section 52, 52.
Telangana government, what is this? PM2, PA2, CMDA, what is this, Mr.? List of officers you have given?
So, at the bottom, the RMD, the RD, that is a regional director, in bottom lots of.
No, we don't want to talk to PA of DMA. We don't intend to talk to PA. Don't give, why are you giving his mobile number to us?
In the act itself, the Municipality Act itself, 252 says.
No. Arey, Mr. You were not there yesterday. Therefore, you don't know. His submission is that the commissioner has passed an order. This regional director means commissioner. How can, against his order, an appeal would lie to himself only? That's it.
It is different from commissioner, my lord. Regional director, municipal administration.
Regional director, see, what does it say in rule 272, 74?
252.
Section. Arey, see section 2 within bracket 74. Section 2 to section 2. Definition. Regional director has been defined. Regional director come appellate commissioner. This is appellate commissioner. Regional director. Who is this? What is the designation? There she is written
This
name.
council,
Mr. It appears to be separate authority, Mr. It's not a case where it appeal lies against this thing. We will direct the commissioner to decide your appeal. Regional director come appellate commissioner. Correct. You have been protected, right?
Yes, my lord.
Protected, no?
Lordship can direct.
Yes,
man.
Yes. Right. We will protect till you file an appeal, correct?
I'm obliged.
Mark the presence. This in
Mayor, please. Lord,
What is to be done?
Lord, these matters were mentioned by the Atkins Naveen, my Lord, for fixing a date. Lord, our urgency is that the matter relates to foreign trade policy. Lord, earliest petition was filed, my Lord, 2011.
2014.
2011. Writ petition was, my Lord, dismissed. Against which writ appeal was filed. Writ appeal was pending, my Lord, almost for 10 years.
11th December.
Yes.
Right.
Lord, some date in November. Well, Lord, now
we are dealing with, the bar knows it too well. We are dealing with old matters. We hope to finish by next 4 weeks. We hope to finish those matters. So that's why we are asking everyone to approach us in November or.
Only one consideration, Lord.
Your Lordship,
The policy was in our favor.
I beg to appear in the connected matter, my lords, that is
Yes.
388.2 of
1 minute. We are fixing a date of hearing only.
A foreign trade policy which allowed us to import. Not some a kind
So
of.
that's 11th December we have said.
11th December.
Right, Monday.
Yes.
Yes, Mr. Sundi, Monday.
Please, lords, I'm in your lordship's hands.
Heard on IA 1 of mark everybody's presence heard on IA 1 of 2023 taking into up to 34. Yes.
May it please your lordship.
Yes.
Senior
Senior.
May it please, Lord. The matter came day before yesterday. With regard to police recruitment, interim order was passed on 21st July 2023.
So we will admit it. It has to be heard. What is there?
But I filed an IA 3 of 2023.
Hey, Mister, this is 23. Please, you come back. You come back. Thereafter, we will consider this IA. There is an interim order in your favor, right? What else?
No, Milord. They have declared the results even after recording the interim orders, Milord, that they will not declare the result.
Sorry, Milord, there is no interim order as such, Milord. Your Lordship, I can see the order dated 1st July.
No, sir.
21st July 2023.
This is what he was trying. This is not a fair conduct, right?
Day before yesterday, I was not. That's why I was not present.
Fine. No. Mister, what have you done? See, you have said before this court.
No. What I said on that day, Milord, it came when the matter came up for
No. This is like playing hide and seek with the court, right? No. Please understand. Like you knew very well that the matter is sub judice. You told the court that till counter is filed, I will not declare the result. Relying on your statement, court said not necessary to pass any interim order. And you next day you file. So on a Saturday, so supposing if the filing is closing, you 5 minutes before you file counter and next 10 minutes declare the result.
Not that way, Milord. We have filed counter on.
But should you not have done this? Now, Mister, what can be done? I mean, they can be punished for contempt. So if you file an application, but result has been declared, what can be done now?
Now the further selection process goes on, Milord. Certificate verification and the appointment orders are not at issue.
No, but this thing, so how many petitioners are there? What happened to you have failed?
Milord, I passed, Milord, because of the local candidate is not treated as on par with the presidential order.
So we will say that the process of selection shall be subject to outcome of this petition. That
They will
protection.
issue the appointment orders to everybody, then no post will be left with me.
No, it is subject to, we will mold the relief, right?
But the
How many
specific
posts are
reasons,
there? How many posts are there?
but the posts notified are 5,010 vacancies.
5,000?
10.
What is the post?
This is the police constable, my lord. What they have done is they have taken the local
So
candidate.
don't fill up
They-
20 posts. What to? 20 petitioners. You fill remaining, but don't fill 20.
Some other candidates may come up again now, Millard, saying that
Then
similar order, seeking similar orders.
seeking similar.
But that cannot be a ground.
No, in this case,
No.
in this case, actually,
So others may come, that can't be ground to
No, I'm not
refuse
saying-
the.
challenge a rule. They have challenged a rule, Millard. Unless the rule sets that, Millard, my appropriate order would be any selection is subject to result of the petition.
And then what happens? Then you will say that there is no, we have filled up everything.
Yes, my lord.
That, sir, now no relief can be granted. All persons, they should implement those persons as parties. The best thing is you keep 20 posts vacant.
But normally, Millard, because it's out of my experience, Millard, once order is given, Millard, series of petitions will be filed. Then series of writ petitions will be filed.
That we will deal with. Don't worry about. This can't be. We have other ways and means to say, we can see that this order shall not be treated as precedent. We can say that. Other will be filed means we can't prevent people from filing petitions.
That is true.
But what is it? What is the issue involved in this? What is the rule?
Recruitment,
What is
Millard,
challenge?
TSHC special police.
Presidential order prescribes that local candidate is eligible to consider in the posts available in that area. But instead of treating the local candidate for the vacancies in the contiguous districts 1, they are treating me confining only to the specified district, which is not contemplated under the presidential order under paragraph 6. Paragraph 6 of the presidential order is violated by
See, we are not strictly going into the merits of at this point of time, but we are disappointed with your conduct of filing a counter and declaring a result. That's why. Not fair.
After 1 month, Millard, count is filed.
No, correct. But
Filing of the counter, Millard, 1 month,
but
Millard.
is it fair when you knew it? Technically, you may be correct, but you knew, Mr. This is, there is a decision of this court only. This I will tell you. 1955 Hyderabad, AIR 1955 Hyderabad, page 1, where this court had expanded the definition of contempt and has held that it is a constructive contempt if you take any action in respect of a matter which is sub judice. This is constructive contempt.
I'm sorry.
And like telling the court that we will not do it, and then filing counter and declaring result because of this thing only.
I
Your
apologize,
conduct-
Millard. That was never our intention.
No, nobody's intention. Like I will take out the entire money from your pocket and say my intention was not to steal. No, I didn't want. I don't know how to pickpocket. Only I have taken. Their intention was not to deprive you of your wealth.
My lords,
So clear.
my lords,
All
we
right,
have
heard.
notice also, my lord, not to announce the results because
Heard on.
we have informed them it is sub judice and you confirm that.
What happened? We are passing an order in your favor, not satisfied. What argue then? What can be done? Argue. Yes.
Only point here, Lord, we have already sent notice also to them not to declare because you already committed to the court that no, you are not going to announce the results. But in spite of that, they announced the results. That's all.
Yes. Anything else?
It's only the next process is continuing, Millard, that as my senior mentioned, Millard, that medical test as well as antecedent.
What
Once it is
process?
done, they'll send it for the training. That's only the issue is here.
Trade. So what is the process of selection, Mr.? Like they have declared the result. So what happens after declaration of result?
Now the certificate verification goes on, Milord, and thereafter the conduct of the candidates will be police verification goes on. Thereafter they issue the appointment orders.
So this process will take time. When was the result declared?
On 5th October 2023, Milord.
Yes, learn it. Mark the presence heard on IA number. One of 2023. A bench of note of sub. Yes, Mr. Bhagat. What you have implemented, right?
Yes, yes. 6 to 21, my lord. Some have been served.
Served.
Some of them are yet to be served.
My lord, effective for respond number 21, in fact, I filed my wakalat, my name was not printed. Somehow because the date happened to be today, I can note it down.
I'm permitted to file my counter, my lord. I'll take out the papers.
Others have filed, Mr. Rao.
Because
Then-
they have to file the counter. Basing on that, we can decide. The university is responsible. The university has to file counter, and medical council has to file counter. University has to file it. But if no, six or seven are served, my lord. I filed proof of memo.
Wait, please.
Who has been served?
My lord.
My lordship, I am appearing for.
So we will allow IA, right? IA notice has been served on them, no?
Not all, not all. Most of them. 6, 7, 9, 11.
So then, we will see by the next date, Mr. Rao notice will be served on all of them. Let him file counter we take it up immediately after vacation.
One small request, my lord. If your lordships are pleased, Lord, this stray vacancy allotments may be subject to Lord result of that part, my lord, because there are few allotments, only few allotments in the stray vacancy.
It's always subject to, even if we don't say, right? How much you file, when should we, 31st October?
31st.
Yes, Lord. Learn it, Mr. Prabhakar Rao, as well as
Phase itself. University is just following the. My selection was made in the first phase, and I was admitted. I paid the fee.
whatever.
So anyhow, I will file my
Central
counter.
government, who appears? Central government. Arey, Mr. Central government. You have got your record. That's important, right? So who appears for central government?
I'm representing Mr. Gadi Praveen Tony also. Please also.
So then you file counter. So and so. Mark his presence also for Union of India. Yes.
Obliged. Obliged.
Higher education.
May I please your lordship?
BNC registration, lordship. Lordship direct to consider the representation.
Who appears? Somebody is appearing through online.
My lordship, I am appearing for the petitioner, my lordship.
We are unable to see you. What, you have put your video off or what? Yes.
Technical problems, just now the camera went off, my lordship.
So Mr. Rao says, have you heard him?
Yeah, he will consider, he said, my lordship.
No, you have to make a representation.
We already gave representation before this.
Where is that?
Yeah.
The petitioner
Yeah,
is an aspirant for seeking
May I please lordships? In the present writ petition, the constitutionality of section 16(2)(c) of the goods and service tax.
Of course. We have yesterday passed an order.
Some cases are admitted by this Honorable Court.
Heard on the question of admission. So what right this, you will deposit 10% of the amount. That is the requirement of an appellate authority also, right?
It's only a constitutional validity question.
You don't want to deposit, you don't want stay, right? Heard on the question of admission. Petition is admitted for hearing. Learned counsel for the petitioner submits.
Please, my lord. In this writ petition, my lord, challenge to rules, my lord, with respect to physical education teachers. Challenge to rules, my lord, of Telangana direct recruitment for the post of teacher scheme of selection. For the post of physical education teacher is under challenge, my lord. On the grounds, my lord, that it is in.
Heard on the question of admission admitted for hearing. Notice.
May I request, my lord, IA1 is filed, my lord, for receiving applications of the petitioners.
No. This all contrary to this thing, it can't be considered.
20. I'm sorry.
This so long as provision is struck down, you are not eligible. How can it be contrary to rule? You are not eligible under the rules.
As per National Council for Teacher Education regulations, petitioners are eligible. State fame rules, my lord, which is totally in contrary to NCT regulations, thereby denying. My lord, in 2017 also, my lord, these petitioners were made ineligible, which is also subject matter before your lordships. Petitioners at that time were permitted to write the exam, my lord. And now, my lord, again, they'll be there continuing.
And you have failed in the examination. Now, that's a good ground, right? Supposing if you are permitted to write and if you don't qualify, the petition can be dismissed. That is the advantage of permitting to receive. Yeah, but like, this is strange, Mr. All rules you challenge, you keep on challenging all rules, right? And every case you file that I be permitted to appear. How can we do it? Contrary to the statutory rule. You are eligible only when it is struck down.
My respectful submission is, my lord, the rules framed by the state is in contrary to the NCT regulations.
So what, I mean, we cannot allow the petition on your submission. That rule is contrary to NCT regulation, therefore petition is allowed, struck down. Will you be able to defend our order in Supreme Court if we allow the petition today?
No, my lord.
Then
My lord,
is he not entitled to file a counter?
Not on that.
Other side will not be heard.
My respectful submission, if your lordships permit these petitioners to participate, in the event your lordships, my lord, takes a view, otherwise at the later point, my lord, the notification could be saved. My lord, otherwise these people, my lord, are going to be made ineligible for the notification by, my lord, that's the only grievance. At least if they participate, the notification could be saved. In the event your lordships takes a view otherwise.
The notification?
Notification for physical education teachers, my lord. If your lordships would, my lord, may take a view that it's contrary to NCT regulations, that the notification at least would survive because the petitioners have participated. Otherwise, my lord, it's just a...
It has to be struck down then, otherwise. Whole process, everybody should be ousted. How many petitioners ineligible?
Not many, my lord, only few are Before your lordships, my lord, now 14 are there.
14. So, and how many will be recruited or whatever appointed?
My lord, if
No, at the instance of 14 people, we will hold that everything is vitiated, right?
it's not like that, my lord. If the rules are unconstitutional,
No,
it goes to the root of the matter, which is only my submission, my lord. I leave it to your lordships.
Yeah, very like this is what every case they challenge the rule and allow us to, how contrary to relief, we can't grant the relief.
Obliged.
Yes, notice, counter. 4 weeks. And we'll permit them to apply. That's all right. Hold on. Yes, we are permitting you to apply. Mr. Third on IA number so and so in the meanwhile, the on
I'm grateful.
a clear cut case of contempt. You should on your own file an affidavit tendering an apology. Clear cut case. You read 55 Hyderabad.
I'll do that.
That's a decision ahead of its times in those days. This court has held that the constructive concept of it has evolved the concept of constructive contempt.
I'll file an affidavit.
You should ideally, not that this we are asking for.
No, it's not that.
Yes. Yeah, 40.
But may I permit you to pass on rules version?
Yes. Yesterday we have heard what. So 9/7 notification was issued, 10/7 to 17/7 was the date, 31/7 provisional list. Then what happened? Then candidates were required to appear before medical board, merit list, 36 out of 36 seats filled up. Then that was made 0.
0%.
0%.
Then the petitioner became eligible.
The petitioner became eligible, 0%. And now, then what happened?
After 2 rounds of counseling, my lord,
2 rounds of counseling.
NMC, my lord, reduced the percentage eligibility criteria to 0.
And you were trying to tell us, now we remember you yesterday told us that you can convert the seats after 2 rounds of counseling.
Yes.
Where is that?
That road, last time kindly see the page 5. Lord.
5. Page 5. Yes.
Roman 9, my lord.
Roman 9.
Selection procedure.
Yes.
Small Roman 2, lord.
Selection will be done as per the counseling schedule notified by the university on website. 2 phases of web-based counseling shall be conducted, and if vacancies arises after 2 phases of counseling, mop-up counseling shall be conducted.
It nowhere mentions about the conversion, my lord.
Now what conversion after?
Lord, may kindly see, Lord, the 3 phases of counseling is permitted, Lord, by the NMC. Lord, after 2 phases of counseling, Lord, the leftover seats, Lord, in the PWD category have to be converted, otherwise they go waste, Lord. They were converted and filled in mop-up round.
Now because mop-up was the only round available.
Therefore, Lord, we converted, Lord, second phase of counseling. We converted second phase of counseling. And seats were filled up.
Filled up. Now
Lord, the
seats were filled up when? 14-10.
Second phase.
A second mop-up stray vacancy round was held on 14-10, right?
14-10.
So then petition has been filed on 1310.
13.
So what is your submission?
My submission, Lordship,
At this point of time, no
the
relief.
seats were not there, my lord, because they were converted and seats were filled with the candidates.
Delay and latches. Madam, delay and latches, we have written medical admission cases. Yes.
My submission, my lord, is medical counseling committee has issued a scheme, my lord. They have to adhere to that scheme.
No, Mister, this you were made eligible on 21/9/23.
Yes, my lord.
So what did you do till 13th of October?
Only on 1310, only on 310, they have issued a seat matrix. When seat matrix, the PWD seats were taken off. Then only we got to know, my lord.
So
before
thereafter, Mister, please appreciate. After 310 also you have waited for 10 days. This every day's delay counts in these matters.
I agree, my lord. I participated in the counseling, my lord. I participated in the even in the mop-up phase of counseling. I was unable to secure the seats. Even though I had scored 139
There
marks,
is
my
one
lord.
more order, delay. Dismiss. The medical admission. Yes. In these matters, Mr. This thing. So what can be done now? There is no seat vacant, everybody filled up. What can we do now? Tell us.
Lordship may kindly see because every student will be under the impression that the university will follow the scheme. We were also under the impression the third round of counseling, when no candidates are there, when candidates are exhausted, then only they'll convert. We were under that impression. The university, my lord, without any notice, they converted and they violated the entire scheme, my lord. The entire process which they have taken out is irregular, my lords.
What can be done by it? Nobody is, those who have been admitted are not respondents. How can we grant a delay? Yes, anything else?
My lord, at least your lordship may direct them for the future. The PWD candidates, my lord, they belong
What it? At the most, we can have sympathy, but we can't grant any relief contrary to law. Yes, anything else?
Nothing else, madam.
Mark the presence in this writ petition. Were converted and the aforesaid seats were converted to general category seats and aforesaid seats
My lords, 42, 44, and 45. Three different assessment years, my lord, which is now this. It is same matter similar to item number 39. We have challenged 62C corresponding provisions 41(2) of SG's ST.
No, we are admitting.
My lords, I may not ask any contrary order than what your lordships have already taken a view of asking us for 10% within 4 weeks. I may ask your lordships to kindly grant us 8 weeks time. Since why I'm submitting is this because my lord, your lordship will see that what I'm paying this now 10% is an additional tax which I've already paid to my vendor. Now your lordship will see here, my vendor, who is an agent and trustee of the department. He collects tax from me.
We are bound by the order. We can't take a different view. You can challenge in Supreme Court.
No.
You don't want interim order, don't want.
I'm sticking
In this petition, the petitioners challenge the validity of the order dated 16 to 18/10/2023, it has been allowed. 42 IA3 is there. 42. No.
The total.
Thanks. No, so then who has supplied different list to me? I have not printed it at my home. Then what is this?
May I clarify this, my lord?
Which is IA? Now
IA
you
number-
want to file objections? File objection, we'll consider the. Yes, let him file objections.
My lord,
Delete heard on the question of this similarly admitted for hearing. Learned counsel. No, we are granting him time. With other cases, there is no order defreezing. This, if you are willing to deposit 10%, then only we will pass an order. Otherwise, no.
We'll deposit within 6 weeks time as your lordships have directed.
All right. So
That
then,
we are there.
heard on IA, praise for and in the meanwhile, it is directed that in case petitioner deposits a sum of rupees, 10% of the amount demanded from it, the petitioner shall be permitted to operate the account.
Well, the time frame is 6 weeks, my lord.
Within 6 weeks.
This is
10% of the amount within 6 weeks, the petitioner shall be permitted to operate the account. List after 2 weeks. Yes. What?
My lords may have the order copy by today, my lord, if it is your lordship's convenience. I'm great.
Certified copy today. 43.
I humbly submit, my lord.
45.
My lord, in this matter, on the last occasion, the Honorable Court has directed me to file an amendment application challenging class 5 of the notification.
No. There is no direction. Why the court will direct?
Your lordship.
Huh?
They have not challenged the rule.
No.
18.
Mr. We have not directed. You have prayed for.
Yes, my lord.
Don't say why. We have not applied for the post of office superintendent. So why will we direct you to this thing amend?
Your lordship.
This unfortunate. That only shows that the court should not interact with lawyers. If we say something, you will take undue liberties.
No, my lord.
There is no direction. This is a factually wrong statement. There is no direction.
My lord, the same was filed yesterday, but there were a few objections, my lord.
You said that we have directed you to file an application. We are telling you, we have gone through the order dated 18/10/2023. There is no direction. Why we will issue direction?
My lords.
We are not the petitioners, Mr. We are not the petitioners in this case.
Yes, my lord.
So why we will issue a direction to you? We don't want any relief to appear in the examination of office subordinate. So why we will direct?
My lords, kindly the same may be listed tomorrow, my lord.
In fact, they have served the copy now. There also, my lord, is not properly drafted.
What to do? See, look at him. What can be done? You permit her to appear. Let her not suffer because the council doesn't know anything.
Only difficulty is,
What can be done?
only difficulty is overqualified. If we permit, my lord, it will open the Pandora box. So many others are also waiting, my lord, with the overqualification. Many of them.
How can Mr. Overqualification be a ground? See, Mr. Yesterday also.
There is a judgment of the Supreme Court. Recent
Where is
judgment. Amit Kumar Das, my lord, was the state of Punjab
Citation.
National Bank.
Citation not reported.
It is unreported, my lord, though it is mentioned as reportable. In this case also, my lord,
Is clear. That's what we are asking. Whether such a class, he says it is.
In this case also, my lord, the qualification prescribed for peon is 12th standard, my lord, which is at page 12. After discussion, my lord,
Qualification you can prescribe.
specifically they said
You can
degree
say
is not
that he should have a PhD doctorate. You can say that.
in the clause.
You should have you can say that he should have a doctorate degree and research experience of 10 years. That you can say. But you cannot disqualify a person that the person who doesn't have the research the person who has higher qualification will not be considered.
It is based solely on the nature of work, my lord, involved in it. And page 12, your lordship may kindly see the first, the qualification prescribed, age, last para, page 1. Minimum age in education, pass in 12th standard or its equivalent with basic reading, writing, knowledge of English. Graduates are not eligible. Now, my discussion is at page kindly 21.
Page
21, page 21, my lord, clause 7.3 onwards. May I read, my lord? Thus, it has discussed with the previous judgments, my lord, and held. Thus, as held by this court in the aforesaid decisions, it is for the employer to determine and decide the relevancy and suitability of the qualifications for any post, and it is not for the courts to consider and assess. A greater latitude is permitted by the courts for the employer to prescribe qualifications for any post. There is a rationale behind it. Qualifications are prescribed keeping in view the need and interest of an institution or an industry or an establishment, as the case may be. The courts are not instruments to assess expediency or advisability or utility of such prescription of qualification. However, at the same time, the employer cannot act arbitrarily or fancifully in prescribing qualifications for post.
In the present case, prescribe the eligible criteria education qualification that a graduate candidate shall not be eligible and the candidate must have passed 12th standard is justified and as observed here in above.
All right.
It is a conscious. It is a
Yes, what do you say?
Here the post is peon melody. In this case also office appointed, which is the last category that is attended.
So what is the qualification prescribed?
7th to 10th melody. Page 18, clause 5A.
And the petitioner is overqualified.
Melody appeared for intermediate exam and also degree melody. In the transfer certificate of the intermediate, it is stated that it is completed. Kindly page 55.
Page
55 of the writ petition.
To ask whether what he has to say.
Clause 7 minutes, second year completed. Yesterday, my lord, my lords, are pleased to wander over the clause that has been described. My lord, instead of my lord, ending at page 18, if it is added, my lord, that in view of the nature and work involved in the category of post which is office subordinate or attendant, then if it is added, my lord, then this problem would not have arisen. Clause 5A. Because nature of the post, my lord, here the work involved is.
Where is the qualification prescribed?
That is at page 18.
18.
5 subclause A.
Yes.
Shall not be eligible as eligible. After that, my lord, in view of that, if that line is added.
Yes. Ask him whether he happens. What do you say?
Your Lordships, I have submitted interfield memorandum of marks, my lord. The basic qualification of the petitioner is SS only, my lord. Even though she has persuaded intermediate degree, she failed both. She is meeting the eligibility criteria, your Lordships. That is my contention, your Lordships.
So the certificate filed by you, it's only a TC at page 55.
Filed by them, we have filed it's transfer certificate.
But if you go to page 53.
Yes, it is failed. It is
failed. And he is pursuing
degree also failed.
Degree also. So technically, if you have to consider his qualification, it would be 10th only, right?
Yes. Technically, yes. But the wording.
As on the date of application, if you strictly see the qualification, it would be 10th plus. He may be pursuing. That's a different issue.
Inconsistencies are there because transfer certificate says second year completed.
Where it
is? Page 55.
No, second year completed that. But there is no certificate to that extent. Certificate says failed. Please see page 53, result failed. So for the purpose of qualification, you have to see the intermediate marks.
My lords may prescribe.
All right. Learned counsel for the petitioner submits that the heard on the question of admission. The petitioner. So what she has not been called for interview, even though.
And one thing is interviews are
heard on the question of admission. The
interviews are over on 14th October. Again, they have to be constituted and then called this class.
Heard on the question of admission. What about 43, 44, 45? Similar?
Similar, no, connected to different assessment teams.
Same order.
Same order.
Made. But in round 3, phase 3 for the purpose of phase 3 counseling for dental melon. At page 19, we got 2 BCD seats were shown in Mallareddy College for women. We got at page 19 bottom, MLDW, your lord's got. We got can I just page 19 below.
What is it, Mr. Rao? What is it? What is the case?
The
petitioner is seeking allotment of seat in BDS course.
Petitioner was given admission in BDS course in Nizamabad.
When?
In the additional mop-up round of counseling.
BDS in additional mop-up round.
Counseling.
Then what happened?
The contest.
When given additional mop-up round on?
Phase 4. Phase 4.
Date.
I just kindly see page 1.
Huh?
This is after 6, but this notification is 6/10/2023.
No, when?
8/10 Milord he was here. 8/10.
8/10.
8/10/2023. He was allotted Milord Nizamabad College.
So, then?
The contention of the petitioner is, Milord, that she could have got seat, Milord, in Mallareddy College in Hyderabad. That is her contention. Milord, the petitioner rank is, Milord, 299.
Could have what means? What could have means?
Well, by submission lordship says, Milord, the fourth phase of counseling, Milord, that is additional mop-up round of counseling, there were 2 seats were available, Milord. 2 seats were available. Milord, a candidate having better rank than the petitioner who had opted, Milord, in the additional mop-up round of counseling.
What is petitioner's rank?
Milord, 299,201, Lordship.
499?
No, 299,201. 29,000, 2,99,001.
And?
The candidate, Milord, who secured admission, Milord, in the Mallareddy College is, Milord, the 2,54,676.
64.
Milord, 2,54,000, 2,56,476 lakhs. Then, Milord, that candidate in the what slided to, Milord, UR. Then, Milord, the one candidate, Milord, the having better rank than the petitioner, Milord, 2,92,498 was given admission, Milord, in Mallareddy College. Both the candidates are more meritorious than the petitioner.
2 lakh.
92,498 lots.
There were 2 seats in Mallareddy College.
Unreserved category. Unreserved category.
2 seats were there.
2 seats out of 2 seats, Milord. One is OC, Milord. And this BCDF, female.
OC and
BCDF, backward class D category, my lord. Both the petitioner and the candidate was allotted of same group, BCDF. So no injustice is done to the petitioner.
you filed counter saying
filed
all
counter.
this. Let him file. So you also don't have any idea what.
Can I just try demonstrate, my lord, how they are? If your lordship.
No. The sum and substance is submission is since those facts are not on record. We are not passing in order and giving him an opportunity to place it on record so that you can. His submission is 2 seats were there. They have been allotted to more meritorious candidates than you. And they, in any case, those people are not before us.
Now, my lord, in the ultimately, my lord,
Huh?
a candidate, my lord, who secured, my lord, 3 lakhs and above.
Where is that?
Fourth respondent.
No, that is, my lord, in the stray vacancy, my lord. Stray vacancy as per the orders of the Honorable Supreme Court, my lord, National Medical Commission.
So let him file a counter, right? Like, how can we decide? Huh?
I'm only afraid that the timelines fixed by the Supreme Court.
No, so what should we do? Tell us what interim order. That to allot seat, I mean, it will amount to allowing the petition. He will challenge the order that we have not been given opportunity even to breathe. Court has allowed the petition. Huh?
Immediately on the reopening day, Lord, can I?
Huh?
30th, Lord.
30th.
Yes. My friend has to implead, my friend has to implead if he wanted to see it. The candidate was.
We don't know. We don't know. I mean, you should implead. I mean.
The candidate who was given seat was impleaded.
Acha.
Fourth respondent.
Yes, respond number 4. Yes.
The notice has to.
So, yes, then notice heard on the learned counsel for the petitioner, Mark. Issue notice to respondents 2, 3 and 4.
Count of files.
This matter, regarding the restoration of the property of the
Huh? Why have you got it listed on a court slip? Court slip you took, right? This is pending since 22. What is the urgency?
There is a encroachment is continuously going on by having the orders. So by this honorable court in writ petition.
So what we can do, we cannot go and prevent the encroachment. We cannot stand there on the, you go, let petitioner go and stand there, prevent encroachment. What can be done?
Here is the counter below Patta lands. As per the counter, they are the Patta lands. As held by the division bench of.
Reply, Mr. to this, what they have said.
No, Lordship.
It doesn't, land does not belong to you, right?
No.
We will remove the encroachment if necessary. Now the order, we will pass an order. Give order of removal of encroachment, we have passed, madam. Order of removal of encroachment. Order we have passed, disposing of the petition. That asks probably Sarita madam. She knows Sarita madam. Yeah, removal of encroachment. We will dispose of the petition.
No, Lordship. Here is the one.
Don't worry, you don't know what order we are, that's why.
Please.
First see the order.
Please.
This under Article 226, we can't decide sitting here in an air conditioned atmosphere whether an encroachment is there or not. That has to be taken care of by the authorities. We are issuing directions. You see the order.
Yes.
The counter specifically.
Everybody will be heard.
It's a Patta land road as held by this division bench of this court.
No, Lordship, it is the Enam land. There is a correction is.
We can't decide, Mr. nature of land in this petition.
Please.
Whether it's an Enam land, and we will impose.
Please.
If you are misleading and is found is correct, we will impose exemplary cost on you.
We oblige for that.
50 lakhs.
We oblige for that, Lordship.
Counter.
He is ready to pay cost of 50 lakhs.
Because, Lordship, it is the purely Enam land. We already filed it for correction of entries as per the direction of this honorable court only, Lordship.
1 minute. Not 84 pages, 3 pages encroachment. You call her. Mr. Basically, you will hear him and the encroachers and decide. We will circulate that order to you. Both of you see. It's an innocuous order. We cannot decide here in a writ petition what is Enam land, what is Patta land, what is what. If there is an encroachment on government land, it is your duty to prevent the government land. How can you argue that no, we will allow our land to be encroached and not take an action?
It's the assertion in the counter note that it's a Patta land by the collector.
Where? Where is the? 3 pages order, madam. Several directions. Petition disposed of. You should keep right. This thing, keep all the orders.
One submission, Lordship. In regard with this, for the endowment tribunal, OA is also filed for the declaration of title in favor of the endowment only, Lordship. That one is the notice.
Who are you?
I am the petitioner. I am protecting the party.
Who are you?
So I am the devotee of the temple from 200 years. Lordship, we are protecting that property from the 200 years, and my name is also registered in the 43 registration also.
So your name? You said that land does not belong to you. How your name is recorded?
So I am the protecting, Lordship. I am protecting from the Ambabhavani temple and Hanuman temple land from 200 years, not now 2, 3, 4 years, Lordship. So we are frequently there were already complete structures are existing, temple structures.
Now they are simply by the orders of respondent number 5, just due to the entry in the Khasrapahani Patta, it is declared as the Patta. So then after appeal, in the writ of petition, it is stated that it is open to the endowment department if it is necessary to take the steps. Till now, endowment department not taken any steps. Then after I filed the PIL 128 of 2016, there I was directed to file the petition before the principal secretary of the revenue department.
The counter, Milord, page 97, the order of the division bench. May I read, Milord, the counter?
1 minute. Give the file, Mr. No, all these petitions are pending since 2022. Yes, what is the urgency after 1.5 years you have woken up and now encroachment is taking place since 22.
No, Lordship. There is
Yesterday it has taken place. Yesterday you obtained the court slip.
No, Lordship, on 16th, 17th, I think so. 3 days back on the 16th.
So what is the urgency mentioned in the petition? That's what the petition is pending since 22, right? Sleeping since 22, all of a sudden waking up. Huh? What were you doing since 2022?
Continuously, we are going to the endowment department and trustees also, Lordship, to protect the.
What can be done?
So, endowment department has not taken any single step against the in protection of the properties.
Mister, what we are trying to tell you is that this writ appeal and IAs are pending since 2022. There was no urgency like immediately to wake up and
no, lads.
That your client is not being hanged by anyone. No death sentence is happening. His house is not being demolished. Nothing.
In this matter, endowment department has to wake up, Lordship. It has to take the steps to vacate the orders which were passed by this honorable court, Lordship. Now, due to that, when they are in the sleeping mode, Lordship, we file this PIL, Lordship. And then after we also file the OAL, Lordship, before the endowment tribunal, the declaration, Lordship. Till now, they are in the sleeping mode also, endowment department. They are not taking any steps in protection of the.
No, you said what is the prayer in the petition?
Sir, Lordship, kindly me.
No, Mr. 1 minute. The land belongs to a temple, right?
Temple lands.
Temple is managed by a managing committee.
Trustee.
Trustees, right? So it is the obligation of trustees to protect the land, its land from encroachment. If the trustees do not take any action. See, Mr., like you own a property. For instance, we are giving you an example, trying to understand your grievance. Supposing if you own 10 acres of land in an adjoining area, suppose it. So the responsibility of the government to protect or your responsibility to ensure that your possession is this thing, right? Primary responsibility is on you because you are the owner. And if somebody encroaches, you will file a suit or seek a decree for removal, injunction, whatever. But the land belongs to the supposing if trust. So how this thing they are responsible for protecting possession.
It lost till Supreme Court. In a trust lost till Supreme Court, they lost.
No, Lord.
The earlier round of litigation, may file along with
So
the
it requires hearing, Mr. This can't be done anything. We can't on the question of admission. The petition is admitted for hearing. See, directions, madam. Removal of encroachment. We asked got it from Bangalore, right? On the WhatsApp. I dictated to you. Not interim, the directions. 1, 2, 3, 4, 5, 6. That is. Yes. But that's not about this thing. Encroachment.
My lords, my lords, on the last hearing, your lordships directed us to file a status report, my lords, about it's the psychiatrist and patient ratio, my lords. This is regarding implementation.
So have you filed?
Yes, my lord, I have filed, my lord, giving detailed tabular forms about it. File it on 18th October. My lords.
Suggestion by petitioner?
Suggestion filed.
Ah. No, what is, where is your report?
My lords, it is USR number is 104512 by 2018th. I filed it. My lord.
Learned counsel for the petitioner.
I furnished the USR.
Get USR what?
I'll furnish.
CSR.
Much obliged.
Okay. 50. Oh, good. Yes. 23.
Page number 22, my lord.
22.
The other two, page number 23, my lord.
23. Okay. 3 and 4, 23.
23, your lordship.
Yes.
Page number 25.
25.
25.
25.
25.
Hmm.
25. 26 Lord.
Hmm. Eighteen, 19.
I have seen.
Huh?
Well, it's a restoration petition, my lord. On the previous day,
Huh? You didn't appear.
but I'm very sorry, my lord. It was so happened. My driver, my lord, he just collapsed just before we start to the court. And I have to take him.
Hold on, IA number. Yes, Mr. Rao. What review petition?
Your lordship may.
I will hear after vacation, not.
I leave. I leave to your lordship.
31st of August 23. Right? 31st. Yes.
May I please, my lord? Lord, this is a case where your lordships were pleased to, my lord, admit the matter and any selection will be subject to outcome of writ petition. My lord, petitioner, my lord, did not file an IA for seeking for permission to write the exam, my lord. But I filed an IA number.
Everybody should be, should pass a general order, Mr.
Yes, my lord.
All examination in the state of Telangana, everybody should be permitted to appear and you should be exempted from even challenging the provision, right? Blanket interim, like extending the period of limitation, like Supreme Court, all proceedings. How many examinations are going to be held this year? Tell us. How many exams in which you will be disqualified? This all, Mr. We don't know.
Lord, this is a writ petition where your lordships already heard, my lord. This is with respect to diploma course where 2007 was prescribed as condition. Lord, connected matter, your lordships already, my lord. In this case, the only probably mistake I have done was I did not file an IA for seeking, allowing these people to participate in the exam. It's a parameteria rule, my lord, which your lordships in the earlier round of litigation allowed. The writ petition.
Where is that?
My lord, IA number.
No, that order. You are saying that covered.
No.
What happened? Who appears?
Your lordships already admitted for counter. Sri M.B. Ramarao Garu, my lord, is appearing in this matter.
Hold on.
IA 3.
Which IA? 3 of 2023. Which examination?
Lord, secondary grade teachers, my lord.
Petitioner shall be permitted after hearing learned counsel for the petitioner. Huh?
Lordships.
There is no 53 in the list. Huh? Why do you give separate list to?
Lordship, I am representing Mr. Gopal Chaudhary Lordships in this matter. These matters are being adjudicated by AP High Court Lordships because the petitioner plant is in
1 minute, 1 minute. 53.
and 54 Lordships.
Yes. 2004 matters, madam.
These are pertaining to APGPCL surplus batch Lordship. Recently, your Lordships have disposed the batch. But these matters are being adjudicated by the AP High Court Lordships. They are pending in AP High Court. These are the case details.
Pending. So how it is listed before us?
That maybe wrongly listed Lordships. After bifurcation, these matters of
Records have to be transmitted.
yes, Lordship. These are the details, case details. Before the AP High Court.
Correct. Huh?
That's a pattern to AP transfer membership.
Huh?
Same has to be transferred to AP.
After so has it been transferred?
No, this please
How she is saying that it is pending before AP High Court?
Those are the details, Lordships, case details.
Details. So how it has come? How it has come here, madam? The records are here, right?
Maybe wrongly posted Lordships.
No.
May I submit, my lord?
Let her submit, Mr. Chaudhary. You are a senior person. If a young person is appearing, don't this thing. We want to hear your junior, not you. We have heard you in that batch. Have we not? Yes. So, madam, how this record is showing like the case is here, records are here, right?
Maybe the records may be transferred to AP High Court.
No, that's correct. But we are surprised how in Andhra Pradesh High Court portal it is showing. When the record is here, the case is here, how Andhra Pradesh is showing without record?
I'm not aware of that.
Yes, Learned Counsel for the parties jointly submit. Yes. What happened? CC today?
Yes, final order. Signed.
So your yoga class is going on? Here, it's only stretching exercise here. Huh? What about remaining yoga? Home. No, you said I am doing yoga here only. So that is only stretching exercise like this. Yes.
Am I permitted to represent Praveen Kumar in Lodge?
Huh?
I'm permitted to represent Mr. P. Praveen Kumar.
Yes.
I'm representing Praveen Kumar in Lodge.
No, that third time you have said. We are asking you about the case.
Yes. Submitting it. Now, challenge the order passed petition number 24709 of 1999. The present appeal is 5 years. This is the matter relating to the freedom fighters mentioned in Lodge.
Freedom
fighters mentioned in Lodge. In the year 1984,
Lordship, in the 1984, the petitioners created a forged freedom fighter sanction orders, Your Lordship, and on the basis of these sanction orders, they were granted the freedom fighter pension.
1 minute. Good. There is a council ground, one that we were saying similar and all that. He has disappeared. That yesterday we decided, he was saying my case is covered, both of them have disappeared.
DRT matter will disappear.
And we are. Huh?
9 and 3 are the not parts.
Nine
The
and-
petitioners, Your Lordship, are the only 1 to 4 who are the accused in CC number.
Nick, but you have written in the synopsis that 9 and 10 have been convicted.
9 and 10 in the criminal appeals were convicted. That is.
So petitioners have been, this,
Then initially, the petitioners were convicted by the trial court, Your Lordship. They were
Mr. Who has been convicted in criminal case? Which respondent?
the petitioners before Your Lordship were convicted
No,
by
no,
the
this
trial
is
court.
Mr. Where is the memo of appeal? It's not there. WA. Which page is the memo of appeal? Review WMP, Memorandum of Writ Appeal. Ah, so there are only 4 respondents.
4 respondents.
So,
The
1 minute. So, who has been convicted? One has died. So therefore, nothing. One has died. Mulugu Rajaya has died.
my humble submission, Your Lordship, is that the petitioners were convicted by the trial court, Your Lordship, stating that the sanction letters were for.
No, no, Mr. Kia, what you are not trying to understand or what I'm.
Hello.
We are asking a simple question to you. You have in a memo, you say 9 and 10 have been convicted. There are no 9 and 10 in this appeal. There are only 4 respondents. You have memo of appeal, you don't have.
I have the memo of appeal.
Then who is the first respondent in the memo of appeal?
9 and 10 were not.
No, no. Tell us we are asking a question to you.
Hello.
Who is first respondent?
It's Mr. Mulugu Rajaya.
He has died.
That I'm not.
Not aware. It's written here in our this thing. Red ink somebody has written. Then this thing, this person was 81 years of age.
Yes.
At in 2005. We don't know what is his age today. So whether he was convicted by.
All the 4 people were convicted by the trial court. This one was also convicted, Your Lordship.
This order was you have written in your synopsis that the Sessions Court in an appeal being filed has only convicted 9 and 10. So we are trying to know whether accused number 9 and 10 are in respondents number 2, 3 and 4.
No, Your Lordship.
They have been acquitted.
They have been acquitted.
Then
the documents, Your Lordship, the sanction letters produced by them,
no, who are these people are, all of them are freedom fighters.
No, these persons approached 9 and 10 for getting this sanction letter. 9 and 10 created, fabricated this.
See,
letter.
brother asking me, does it understand Government of India engaging such a council? Able to comprehend.
Page number 37, Your Lordship.
Please follow the question first. 9 and 10 are the legal heads. They are the legal heads of.
Who was the freedom fighter, Mister?
Sorry, Your Lordship, but what I'm trying to convince Your Lordship is that.
No, then you
call.
synopsis. You discard the synopsis.
This you call Mr. Praveen Kumar. We will pass it over. Let him come.
Praveen Kumar went to Narayan, Your Lordship. Praveen Kumar went to Narayan, Your Lordship.
Tomorrow we will take it up. Ask him to appear. We can't, you are unable to tell the facts. What can be done? We can't decide like this. You think that we are not understanding. And you give us a wrong synopsis. We are
synopsis created the confusion, Your Lordship. I will submit a fresh synopsis, Your Lordship.
You should confusion. There is no confusion.
No, my synopsis created that confusion, Your Lordship.
Perhaps we should write this, that you are saying that this is a wrong synopsis, and then.
Sorry, Lordship. Synopsis was based on the facts, Your Lordship. Because that fact was not properly brought in. We'll find something in the need for
What to do? This Union of India Council.
Even on merits, they all have been acquitted. This appeal is out of the review.
We are not pressing this appeal. There are two appeals, Your Lordship.
You're not pressing this appeal?
This is appeal against review order is not. We are not pressing.
His appeals are filed against the review.
Yes, sir. He's arguing no.
There are.
No, this LPA you do not want to press.
We do not want to press.
Then why you did not tell us that we did not? You are arguing the case.
The second one I am expected.
So which appeal you want to withdraw?
This first one, Your Lordship.
Tell us the number. First one and this. Then you will file a review that I did not intend to withdraw this.
This
What, Mister?
55, Your Lordship. Item 55, writ appeal number 1185/2005.
In 55 there are two writ appeals, madam. So which appeal you want to withdraw?
1185.
So you have given synopsis in this only, 1185, which you want to withdraw.
Your Lordship, I submit a press synopsis, Your Lordship.
You see, Mister, you have an additional responsibility. You are representing Union of India. Should it be done like this? That you are filing a synopsis in a case and you have not told us. So when brother said, then you are saying that I don't want to withdraw. I want to withdraw this.
My Lord.
What, Mister?
My Lord,
we are reading this, like this thing, wrong synopsis, incorrect facts we are reading and we are putting questions to you. Thereafter you say that I want to withdraw this.
Your Lordship, I have it tomorrow. I'll submit a press synopsis, Your Lordship. I will come on.
No, what?
Sorry for the inconvenience, Lord.
No. There is no question of inconvenience. We will decide ourselves. Don't worry. Which case you want to withdraw? Otherwise, we will decide both of them. If you don't know, we are not dependent on you, Mister, for deciding. It's unfortunate. We will say that you don't know anything about the case.
1185, Your Lordship. 1185.
Learned counsel for the petitioner seeks leave of. Write his name. Otherwise, he will say, I never said that I will withdraw. They're capable of saying he doesn't know what. So, where's the same? This is writ appeal. Mulgu Anjaniya. This. So in criminal case, they have been acquitted.
Criminal case, they have been acquitted, Your Lordship, but the fact remains that the appellate court has clearly observed that the sanction letter that was brought by the petitioners was forced. Lordship, you kindly see the.
No, Mister. What are you arguing?
They have been acquitted by the judgment in criminal appellate court. What lies further? Please see the.
No, if the this thing, I mean, can you rely on an order passed by the finding recorded by a criminal court for this thing? They have been acquitted. Have you challenged that order? Then, if you have accepted their acquittal, what basis you are this thing? How can you be permitted to deprive them the benefit of pension?
These petitioners were, the accused number 9 and 10 were acquitted because they have fabricated the documents. The sanction.
Again, you are saying 9 and 10, there are only 4 respondents.
Respondents, respondents rely upon the documents fabricated by 9 and 10. That is what my.
9 and 10. So
9 and 10 are the accused in the criminal cases, Your Lordship, and these are the.
They are not parties here.
They are not.
That the fact remains that they have been respondents who are convicted by trial court. In appeal, they have been acquitted. That, and you will not challenge the order of acquittal any further. How can you withhold sanction? What?
Only I am trying to impress Your Lordship is that because.
Nothing impressed.
Category found that the document that was brought by them was fabricated. It was the documents.
So how they have been acquitted? If they have been acquitted, what have you done to challenge? You should have challenged that order. If you have not challenged, thank yourself. Yes. This intra-court appeal See,
Right, my lord, the reports were called for, my lord, by orders of the lordship, my lord, dated 15 September. My lord, third respondent has given the report day before yesterday, my lord. I was ready with my note with regard to that report. But today, my lord, in the court, 1, 2, and 4, my lord, I've given the report just now. 1, 2, and 4. My lord, let me have a look at the reports, my lord, and give my note.
31st.
Yes.
Learned amicus curiae. You are appearing as amicus, right?
Amicus.
Mr. Learned amicus, Mr. D. Prakash Reddy, learned amicus, submits that the copy of report filed on behalf of Yeah, Mr. Prabhakar, if it's a contested matter, then we won't like to reserve. If it can be decided, then you argue. Most welcome.
Can go after vacation.
So, when?
Date after 30th, no?
30th. 6th or 7th, 1 minute. 6th or 7th November?
Much of best.
7th November. Let mark the presence, Mr. J. Prabhakar, senior.
I am for
Yes, mark his presence also. Learned counsel for respondent number 3. So we will take it up on 7th November, Mr. 7th November 2023.
4 IPA.
Yes.
1 to 4 IPA. 1 to 4 IPA, EPS 5.
5.
Is appeared for 5.
5. And 1 to 4 he appears. Oh, yesterday's case, where is it gone? Those counsel who argued we dictated,
Yes, my lord.
both of them have disappeared today.
The connected matter has to come today.
Where is it?
Not
We
in the
don't
list.
know where it has gone. Yesterday we dictated
Yes,
the
but
order.
one
No?
it has been disposed of.
He
The
was
other
saying-
it has to come today. The other connected matter has to come today, my lord. It was in the list.
It has
Yesterday,
been dropped or what happened? Yesterday we decided one case, no? 144? Why?
it has to come in this week.
No, madam, yesterday it was listed at item 29. How it has gone to 124? Huh? So how then it has, it had come at item 28? You call that both the councils. You show their name. Madam, it's a covered matter. You show their names, both the item number 144, whatever. How it has? Really surprised, Mr. Yesterday it was item 28.
I thought it would be the first matter today.
We thought that it would come as first matter and we will be able to decide. 144. That is the similar matter. Scroll, show the names. Yes. So but then how that earlier list was prepared? What I feel to do yesterday you're dealing with these both matters have to be issued. No, but where from these cases have come? No, madam, one thing we would like to understand. Yesterday's list, it was item 28. So, no.
So first case is complete, but it takes up the first case. Then children section of batch not connected with the system. So now present only is in the case 2016.
No, this item number, all these cases were there in the list. Sorry.
It is their option.
So they are coming up.
Almost all are disposed of. So 2016, with the year wise, it has stated that in the contracts. Then
You tell Mr. Reddy to explain. 4:30. You tell him to explain this, that how item 28 has been listed as 144. Who has done it? And you show their names. Yes.
Lordship, I'm appearing for respondent number 123, my lord.
Hmm.
Lordship, on the last occasion, I've sought an accommodation from your lordship, but since your lordship asked me to be ready, I'm ready with the matter.
No, it has to be argued by appellant, your respondent.
Yes, my lord, I'm ready with the matter. I'm just reporting.
Then appellant has to argue why you are taking upon yourself the responsibility.
Appellant is Mr. Praveen Kumar ASC, my lord.
Huh?
Lordship, one
Memo has
fact.
been filed, your lordship, on 13/10/2023, stating that.
You want to withdraw the appeal?
I'm for the,
Huh?
I'm appealing for the appeal.
You want to withdraw the appeal?
No.
No. What memo has been filed?
Lordship, one
Reporting the
fact.
death of responding number.
Huh?
Reporting the death of responding number 3.
Lordship, one fact before learned friend starts, my
What
lord.
is this matter?
Lordship,
No, Mr. This 11:10 we had said 16:10 no further adjournment. That's why, madam, we don't adjourn the cases. No, that's why when you stand up and say, because these order sheets you don't point out. There is an order, we cannot violate our own order.
yes, my lord, since your lordship's order is there, I'm saying I'm ready with the matter.
No, but you were seeking an adjournment. It's not fair.
Asked
No, day before yesterday or whenever you stood up and said that I want an adjournment.
It's being led by a senior counsel. my lord.
Nothing but senior counsel or everyone is bound by this order.
I'm ready, my lord, I'm ready.
We have said no further adjournment shall be granted.
Lordship, one fact I may be permitted to bring to your lordship's kind attention. In 2008, your lordship, we have filed an IA to bring on record the LRs of respondent number 1, my lord. No steps have been taken, and recently we found out that respondent number 3 also passed away, my lord. We filed a memo to bring on record the
The
LRs.
memo has been filed, like this
Yes, my lord.
legal representative. We will allow it. What is that?
What is it? IA is not listed.
It was allowed in 2008 itself, my lord. But steps have not been taken to implement them since they are the appellant.
See, brother, they are not required to file an application. But memo is what is the you are practicing here?
Yes, your lordship.
Hyderabad since when?
2004.
Huh?
2004, your lordship.
4 means how many years of practice?
I'm almost 23 years.
23 years. So, what is the procedure like when somebody dies, a party? So you file a memo, no application along with affidavit, nothing is required.
This application, this memo is filed with the respondents. I have to bring the legal aids on record. I am for the appellant.
So you said memo has been filed. That means you are saying that memo has been filed means you have filed it.
Respondent filed a memo stating that.
You say that respondent has filed. Memo has been filed, you said.
Sorry.
What is Mr.
My lord, perhaps I may not be making myself more clear. I'm sorry for that, your lordship.
No, you are saying memo has been filed. So what should we presume? That you have filed a memo, right? They want an adjournment perpetually. They want this case to remain pending forever till she is designated as senior advocate.
No,
We will argue after another 20 years. We will keep it pending. We can issue a direction to list it in 2045. By that time, you will be designated as senior counsel, right? No, this is what you filed a memo saying that I am ready.
This matter got lifted after a very long time, my lord. I have contacted the clients and they informed that they have passed away. So I filed the memo to just do the needful, my lord.
Though this court had passed an order on 11/10/20. Let the petition be listed before a bench in which one of us write his lordship's name is not a member.
Trying to log on the virtual, but he's unable to.
My lord, may I please, ma'am? Just logged in.
Is there?
Yes.
Just
You know, what is the matter, Mr. Murthy? We would not like to reserve.
Small matter, my lord.
Ah.
A GO was issued in 2006 stating that state would fund the construction and maintenance of the various religious institutions, Waqf especially. But that was challenged by saying that it is violative of Article 27 and especially Sirur Mutt case. There's a short point involved in this. That's the only issue, my lord. Page 16 is the impugned order, my lord. 1-6. That's a typed copy, my lord.
Yes.
Read, my lord.
No, Mr. This is a public interest litigation.
Yes, ma'am. That was in those days, but bill was not given a different number.
No. There is an order dated 13/12/2006 is saying that it's a publicity interest litigation.
No, because we did not file the tax matters, etc. Man, that's the reason we filed an MP to bring on record that he's a taxpayer. That's the reason. Because document, see, we filed an additional affidavit and brought all the in WP MP 2007. We filed it to bring to record the fact of all these things along with the relevant GOs mentioned therein.
This is a public interest litigation, right? Pending since 2006.
Yes, sir.
Like it requires consideration.
Two minutes. That's a short point was involved was that, but they filed a counter stating that government has a duty cast upon to fund the religious institutions also. The counter affidavit filed in 2022.
It's not that easy, which you think. You will close in 2 minutes. Who will write the judgment? Not that easy. Yes. You don't want to file any counter to this reply?
No, man. That's the only, there should only a legal point.
All right. Let the petition be listed after ensuing. We not be like service. No, result. Nothing is casually being short. Yesterday we have supper.
And I may permitted to file the. I may permitted to file the relevant Supreme Court judgments, man, and bring them.
That's what we feel. I mean, that you are taking it very casually.
No, man, not casually, man. My colleague is there to pass on those judgments to your lordship.
No, Mr. Please appreciate Mr. Reddy that we are 1 day away from vacation. We told you in all fairness, we told you that we would like to take. No. See, for you it's a very short matter. Who will make a research? Who will find out judgments violation of Article 27? This thing.
I asked my colleague to bring the judgment. Is there ready? But I'll file it in the record so it'll be easier for along with the relevant paragraphs, etc. Noting down the paragraphs. 2-3 judges. I'll do it. Obliged, man.
I already passed on the judgments, madam.
Anyway, we'll file it, man.
All right. If you insist for hearing, we will write a judgment to date.
No, I'll
please
file
file.
those judgments, Bharat. But only one judgment I brought in. But I'll
Who
file those
who
judgments.
appears
The
for
last adjust.
respondents? Who appears for respondents, Mr. State Government? The council is ready. He has filed judgments. We will have to write judgments.
Only one judgment, Bharat. I'll bring one or two judgments on record. I'll file them along to be compilation, Bharat. Bharat, I'll file them.
Yes, please. Go ahead. Yes.
But I thought that your lordships have just take the word. So your lordship permitted to file those two judgments. I'll file them, my lord, on vacation.
So we have no. He's saying that I have filed it. So we don't want to give. See, Mister. We don't want to give an impression that the court doesn't want to hear the case. Please go ahead. Please go ahead. No, since no, I was this 17 years you are waiting for this petition, and all of a sudden you are if the urgency is there. Yes, please go ahead.
Your lordships have indicated that.
Please.
Will take it after vacation. I'll file those two judgments, my lord, on the record, so that I'll file those two judgments, sir. Lordship may. Lordship may.
No, but you say something, your colleague is standing says something else. What to do?
No, man. I asked my colleague to be there to ready to give it if your lordship
No.
That's all.
After we have passed an order, he says, I have filed the judgment. So that means he wants to tell that. No, sorry.
But I'm sorry.
Ready, Mr. Ready?
We have already filed our counter.
So be ready. Senior counsel is ready to argue. Go ahead.
Yes. Your lordships have indicated
Please,
that.
please.
Your lordships have posted after vacation. I went out of the court. I'm sorry.
No, not sir. There's no question of being sorry. We thought that, but all of a sudden, as the vacation approaches, it's very good sign to see that everybody is enthusiastic about arguing cases. Fine. Please. Go ahead. Yes.
As a lordship, please, but I thought.
So this is a public interest litigation. Who are you? Businessman.
My lord,
Businessman.
My lord, he is a taxpayer.
Chairman of committee.
The lordships permits me to go ahead, or shall I file all those judgments in the record bed so that the lordship may take it after vacation? I leave the lord.
Then leave it to lordship. Is your colleague is saying I have filed the documents.
I asked
we
him
don't
to be
want
ready.
to. Please, go ahead.
I asked
What
him
to
to
do,
be
Mr. You are yesterday also. I mean, the council, two councils forced us to hear a case, and thereafter, to our utter shock, the council for respondent told that I am not appearing in the case. This is what is happening. So we got up the dictation of the judgment. We got up yesterday at 5:40. This is what you are compelling us to write. We will deliver the judgment right away, Mr. We will not keep it pending. You argue. Yes.
May I submit on to it? I apologize for my junior colleague's miscommunication that he was there ready with the judgment. He has not filed it. But copy of the judgment was there ready to pass down to your lordship.
He has filed it. He has filed it, he says. We don't know where he has filed, but he says he has filed.
But some miscommunications, I pass on the judgment. That is only lordship said. I'm sorry, extremely I'm sorry.
Interesting. So one case we asked that they are this all privilege problems, public interest litigation. List after entry.
Much obliged.
I remember the petitions about this is a PIL filed by 4 societies in 2006 for the enforcement of 2 enactments. One is the Andhra Pradesh Prohibition of House Slaughter Act. The other is the transport.
The other petitions are pending on this repeated.
My only request is I have not been able to contact my clients also.
No, that's the public interest litigation. It is our baby. You can't, we cannot withdraw. We can't dismiss.
For the festival of 2007. This is for the festival of 2007.
Infructuous.
6 and 7. It can be closed as infructuous because Even for the latest festivals, new repeats are.
That's what I have myself dealt with this cow slaughter thing.
Yes.
No, but this is cruelty to animal.
In the wake of Bakrid festival, performed on
2007. Nothing survived. In this public interest litigation, the petitioner
Commercial tax. My lord, in this cause doesn't survive, my lord. The provision
Does not.
for challenge, my lord.
Ah.
In fact, that was dropped by the government, my lord.
Learned.
Provision is omitted, my lord.
Submitted. Learned counsel for the in this writ petition, the petitioner has asserted the validity of nobody is appearing. What is this is bill? What no appeal? 13/12/2006. What is this? All in progress. Page 14. Nothing survives. Page 15. No prayer I am seeing. Prayer. No prayer. What was the prayer? Prayer is direction, not supplying information, right to information. Yes. None for the appellant. The grievance. From where? Yes.
Page number 18 is
18. First case.
C. Ramchandra.
Page 18.
960.
298.
Page number 18.
18. All right. Certified copy today. What? See, nobody has appeared. See, madam, which page? They don't know. You show the name of that council. Show the name and call when he comes. Takes.
Wait, please, your lord.
Hooray, Mr. Rao.
I'll shoot you, your lord.
Yes. What date? Which date? Any date after vacation.
Your lord is any date your lord fixes, I don't know.
2nd November. 2nd November.
2nd, not after 4th, your lord.
4th.
4th.
No, 4th. We don't know. 4th. 4th is a working. No, 4th is Saturday.
3rd, your lordship may have it. 3rd, your lordship.
3rd is again a Friday. We can have it on 7th.
I'll leave it to.
8th Sitam. 8th. List on 8th of. Mark their presence. List on 8th of November 23.
I'm for responding.
Ask him. Contested matter.
It's a contested matter. You're appearing for which respondent? Come this way.
I'm for respondents. The appellant is also a private person.
What is the matter? What is the matter?
It's for R6 to 9.
This is a.
He's having for R6 to 9. It's a tenancy.
My clients responding, they are the protected tenants. They have filed the writ petition. That writ petition was allowed. As again, the writ appeal was filed at the instance of a.
Nobody is appearing for
private person
capital.
before.
Tell him nobody is appearing. We'll list post after vacation.
Government is also a party. Respondents.
No, there's no
Three,
representation
4, 5.
from the appellant.
Yes. No one.
Just after vacation. There's no representation, sir, from the appellant.
Hey, Mister, go there and tell him.
Yes, let it be. No, I have to.
None for appellant.
Submitting that I am for
Learned-
respondent.
Yes, none for the appellant. Mark his presence, learned counsel and so for respondent. List after ensuing.
Acha. Shall I write my?
Huh?
It's not. Acha, not.
What?
Okay.
He wants to write it here. Said not.
Not required. One from me. That we need.
I am appearing, I am for the petitioner, my lord. In this writ petition, I met with an accident. I underwent surgery. Lost my post after 3 weeks, my lord. I was bedridden.
Learned counsel for the appellant. Praise for who has appeared through video.
After vacation, you know. After vacation.
What is the issue?
Farmer suicides, you know. Five districts have been covered, you know. 3 district collectors have already filed counters. I have to file counter on behalf of 2 district collectors, you know.
Sorry, this is 2007, Mister. What?
The next bill 101 of 2022. This has been connected to bill 101 of 2022.
Item 69, madam, you write. Learned. Yes, madam. So he wants to file a counter.
Yes, my lord.
Mark the presence.
14 November.
Which case? See that those councils have run away, not coming. Madam, you are showing in scroll, right? The names of those people, 144. Not coming.
Got it. In this.
All right, yes, go ahead.
But in this case, other side informed me, brother, they are taking time for tomorrow for getting instructions, brother. Mr. Prabhakar Junior told me that he's taking time for instructions for tomorrow, my lord, your lordship, so please. It appears that he.
Mr. So and so, praise for adjournment. Adjournment. List tomorrow.
Tomorrow, I'm deep.
Then why should you take a lunch motion, mister?
I do it. I'm sorry.
Yes.
Date, please, your lords.
Which date?
No, I have filed application for a lordship's kind consideration. The petitioner's land is a non-agricultural land upon the land.
What?
Enemy custodian of enemy property is claiming. State government is claiming as a access.
In this matter, my lord, the additional grounds are prepared and served on me only yesterday, my lord. I need time to answer this additional ground.
I leave to your lordship.
Mark the presence learned. Yeah, how much time, madam?
2 weeks, your lordship.
Praise for is granted 2 weeks time to enable her to file counter.
Much of.
Please. Says
71.
Court appeal has been preferred by the Water Board, Hyderabad Metropolitan Water Supply and Sewerage Board has filed the writ appeal challenging the order of the learned single judge.
What is it? It requires a detailed hearing.
It requires.
List after ensuing. Dasra.
Lordship, I'm the appellate lordship. We are given the NOC to the party lordship.
Huh?
NOC to the, I given to the NOC to the party lordship. So,
Mr. Write his name, learned count.
lordship, kindly the report my statement lordship. Record my statement.
Yes, we have already recorded.
Recorded, mister, that you don't have instructions to argue the matter.
Yes, lordship.
If he is interested, he will seek restoration. Why should you bother? You have done your duty.
Yes. Much of.
What is item 73?
Third party's appeal will be granted.
Huh?
It's a third party's appeal, not party to the writ petition. Leave granted, but very innocuous order, not only to dispose of representation.
None for the appellant. So it has to be heard.
Yes.
List after ensuing. Dasra Vike.
I'm for the appellant, my lord. Intra-court appeal, my lord. The HMD is the appellant, my lord. On the last occasion, the respondent filed a memo, my lord, stating that respondent number 3 died. We filed IA1 of 2023, my lord, to bring his LRs as respondent number 7 to 10, my lord.
You appear for LRs.
What is to go your in the other appeal?
Heard on IA1 of 2023.
May I please, my lord, I am appearing on the Lord,
Ah.
may kindly consider, my lord. Lord, may grant some time, my lord, I'll argue this matter. I'll get it.
Not today.
My lord, yes. I'm handicapped with bundle, my lord, some personal difficulties.
List after ensuing.
I am appearing for this matter, your lords may kindly consider.
Ah.
Since 1978,
My lord, I will.
petitioner's land was requisition, later acquisition.
Hey, you can't, Mr. Today, all your cases are listed today only.
I have been yesterday, your lords, I have been waiting. I am only trying to say same 8th, let my learner friend be ready on that. So that
Yes.
This is 78 matter, your lords, the land has been acquired, no compensation is paid.
Any day after vacation.
Huh?
Any day after vacation.
Any day.
8th November, your lords have posted another matter.
No, so on that day you will argue that case. So
This also your lordship may now go. So that
we will list it before that if you want, Mr. Rao. 1st November?
1st November I am
not there. Okay.
No, your lordship may have it on 8th finally, so that I can
Not
take
the
it.
presence. Learned count. What is it, Mr.? Hmm? Chief. But this act, the right to survive. No, none for the applicant. List after ensuing this. Hmm.
Respondent number 4 in the writ appeal and petitioner in ATF.
Hmm?
Writ appeal, I appear for Act 4, your lordship, and item 8.
Applicant. Applicant? Nobody. What is it about? I just tell madam what is without looking into the what is the matter?
I have full code, your lordship, I have not gone through.
Huh?
I have full code, your lordship. I am unwell, your lordship, I have cold, I have not gone through the binding.
You have not read the file.
I have called your lordship, I have not gone through the bundle.
Acha, so there, yes, that's what we are saying that you don't know. Even for the apparent so and so. Yes.
Make please, Lordship. Lord, this matter pertains to collection of Lord market fee and the manufacture and Lord sale by the petitioner companies. Lord, the one of the learned judge Lord allowed the writ petitions. Subsequently, in another batch of writ petitions, Lord, when the another learned judge Lord disagreeing with the order of the learned single judge Lord, refer to the honorable bench. That's how this matter is listed before last. In this case, there are two state market committees are involved, Andhra Pradesh and also Telangana. I only request also to let the special counsel for AP may be directed to be printed, so that you will also hear the matter. There is also another connected matter also there, 5258 of 2008.
5258
of 2008.
List. Oh, yes, madam. That is WP.
Yes, WP.
List for analogous hearing along with WP number.
Respondent number 4.
I have to respond number 2, ma'am.
Item 82, my lord, I am effective to represent Mr. Aineni Venkata Prasad.
Yes.
My lord, Mr. Venkat Prasad, my lord, has a personal inconvenience. My lord, he could not come to the court today, my lord. Lordship may kindly, this matter may be had after
Please.
vacations, my lord.
List after so and so. Learned Mr. So and so praise Mr. Dheeraj Singh, Learned Counsel.
I appear for the petitioner, my lords, representing counsel on record and Sridhar Reddy. My lord, may kindly have it post vacation, my lord, the counsel on record has got some personal inconvenience.
What is the matter about, madam?
For this, the writ petition is not quite challenging the EPO order of assessment and demand notice, but it will not property tax imposed on educational institutions. Educational institutions, charitable trusts are exempted under section 88 clause C of the AP Municipalities Act. So this is the matter.
This is the matter, that's it. What else? Then nothing else to be argued over. It is exempted. So what will your senior do then? This is the case.
Yes.
Who appears for response? List. She prays for adjournment. List after ensuing Dasra vacation.
Obliged me.
My lord, I am the petitioner here and the counsel is unable to appear due to personal inconvenience. Kindly grant 1 week time.
13% list after. Prays for adjournment. List after ensuing.
Counsel for petition. As the petitioner advocate is designated as senior counsel, will file a fresh wakalat on this.
He's been designated as senior. What were you doing all these days? It's a 2008 matter. It's been designated long time back.
We could not locate the file.
Waiting.
Waiting
for the case to be.
Where I got it.
You were waiting for the case to be called, and supposing it would not have been called today after this thing with the holidays, you would have made that statement there. Correct?
But in fact, cause would not survive.
Cause does not survive. Why?
The theological KKC prayer, they are challenging the rules issued. Regulation of unapproved illegal layout rules 2007. But in the year 2015, after the state has been formulated, that the new rules have been issued by the state of Telangana.
So these rules have been repealed.
Repealed.
Oh.
I don't have any instructions.
Better don't have. What to do?
May I pass on the new rules?
See, the petitioner in this petition has
Lord, I beg to appear in this matter. Lord, though the prayer, my Lord, is lengthy one.
After any day.
Very well. I need
Where senior counsels are appearing, the presumption is attested. We don't want to reserve it for 2 days.
second week of November.
November. Yes, Mr.
In fact, 2 more senior counsels also appearing in this matter.
Huh?
2 more senior counsels are also appearing in this matter. Today they are there.
Okay.
Second week of November.
Second week. What? Yes, when do you, what, 7th November?
Very well.
List on. Mark the. This is vacation motion letter. Vacation motion. This order, this thing, interim order. Yes, Mr. Counter has not been filed in these petitions. There is an interim order operating in this 303 WP. Item 88. Mandal Revenue Officer Ram Goodnam.
Sorry, brother. Name is not printed. I couldn't notice.
Office is none for the petitioner. Office is directed to reflect the name of Mr. So and so. It is not to close an existing road and not to make any construction on the park.
Yes.
But instead you go through it, otherwise we'll pass an order.
In this, I appear for the appellants. Seek adjournment, my lords, matter. I appear for the appellants, my lords, it's a state, my lords, on behalf of advocate.
What is it about?
It's a ULC matters, my lords, urban land sealing matters, my lords.
Urban land sealing?
Yes, my lords, urban land sealing matters.
The ULC matter where your lordship, it has been declared an excess land, and the state government subsequently your lordship state that it does not come under excess land. We have challenged by filing a writ petition stating that this can't be an excess land without issuing any notice to us. These proceedings have been initiated. The Honorable Single Judge, your lordship, has allowed our writ petitions against which they filed writ appeal.
After vacation? Arey, Mr. We were looking for you where you had gone. We thought that you are going to give us a disposal. So we reflected your name also. You said no, same order. Huh? Not that we are talking about that case, yesterday's matter. Huh? Yesterday's matter. Huh? That's what we tried to understand how it has gone to 144. So,
Because year-wise,
1 minute. So 89 to 107 after vacation, after Dasra vacation. So which Mr. Which is the case which can be decided? 144. 144 madam, right? Yesterday's order. Same order, Mr. Mr. Ramna.
Different order.
No. So therefore it is remitted, right? So you, madam, disposed of, right? That Sarita madam, ask 144. Where is? You are the only case, mister. Only case disposed of. 144, right? For the, give that 144. All right, so we'll pass the order. Yes, 144. So then 108, madam. One zero eight. Madam. Yesterday's we passed an order, no? So 144. So no, we don't want you this 144 same order. This Madam, display that number first. First. Yes.
My lord.
Hmm.
Representative Counsel G.V. Shivaji, my lord. The issue is relating to regularization of the petitioners, my lord. Regularization of service of the petitioners, my lord. Petitioners 1 and 5 were allotted to AP, and petitioners 2, 3, and 4 are allotted to Telangana, my lord. So, implead petition has been filed, my lord, 1 by 2017. Proposed respondents has to be brought on record, my lord.
Notice has been issued, madam? No. Issue notice of IA1 of 2017 to proposed respondents. What is it? 109, madam. Challenging the regulations. None for the petitioner list of You give we want to see whether it's infructuous or what. Clear. House rent allowance. None for petitioner list of same one.
Sorry for having not having any side but purchase to the challenge started for 2019. Maybe relating to the elections, but it is very similar purpose.
No, it does not survive, right? Then it comes. See that. Usually do. Why at least you know it. Otherwise they won't say it. They wait for it being caught. They could have said it. He knows that they wait. There must be stay in this.
Private respondents are there.
Huh?
Private respondents are there.
Ah. There is a stay. Then it must have been decided by now. See the direction.
Yes.
There is no interim stay. So what do you think, Mr.? Disposed of implicated parties.
By the councils.
Operative portion read.
Yes, Lord. In case such proceedings are initiated within 8 weeks from today, they shall be treated as having been presented with the period of limitation. Pending such exercise, no steps shall be taken for enforcement.
There is no stay.
Yes, it can be closed as infraction.
Yes, this intra-court appeal has been filed. Now what incomplete petition, madam? Notice not issued. What is incomplete? You see what is incomplete petition? You can see the other file in the, they should start his sitting. You see the next file by the time.
This one is 3 to 5.
3 to 5. Complete petitioners. Who want? 3 to 5. Who? Can you not see? Whom they want to implead? Where is this? Three to 5. They have filed an application for impediment. None for parties. List after. It's matter also same, I think. Same. What is it? Ah. What is the matter about WP? He should have seen, no, by opening, we are asking him, not doing anything. You open the next file, put a flag on the prayer clause. Same. Compensation. List after. None for parties. Give it. Hmm? What? Huh? After Dasara vacation. None for parties.
The matter has become infectious, my lord.
But you should tell, no. In the beginning itself, you are waiting, supposing it would not have been called today. You are waiting, right? Infructuous, anybody can tell this item has become infructuous. Learned counsel for the appellant submits that. We told them, they don't take any interest. See, this case also, like they are waiting to be done. Like ordinance you saw, this also, supposing it would not have been called, give madam, you give immediately. But this person should also help, no, sitting there doesn't. Common judgment. What happened to, can you find out, madam, from this thing, order dated 28/4/2010, passed in Huh? No, madam. What I want to know is what has happened to this order dated 28/4/2010. Whether it was challenged in an intra-court appeal, that you can't find out. You can't find it. What happened to the order dated 28/4/2010 in WP 26688/2007? This is what we want to know, whether any writ appeal was filed, whether it was dismissed, allowed.
Number.
This is 9399.
On the website, you know, the repetition number is given.
It should have been. It is pending. It must be. This is the repetition. Oh. Yeah. So what is now? It must be batch of details. No, it is just clear. None for the appellant list after. Yes, Nick, 118.
Become KP for labor matter. Fine name matter.
No, that's correct. Your name has been brought. What is the case?
Case is civil supplies partnership.
Huh?
Civil supplies.
Dealership vacancy. Huh?
Only 1 week time and then
Nothing.
we'll find what.
What's your name?
TV Srikant.
No, this grievance does not survive this. See what is the order. This is allotment of a fair price shop. It was meant for BC women category. You filed the petition saying that they are going to fill up with SC candidate. They have said that we are not filling it up with BC, that SC category. So therefore, this thing, your grievance does not survive.
After vacation, my lecture, I will accept.
No, there is nothing what there to ascertain. That's what this is the order, Mr. There's nothing wrong with this order. You have sought a direction to fill up the vacancy with BC women candidate. They have filled up. What is there? It does not survive. In fact, you wanted your selection. That prayer you didn't make. That allot this fair price shop to me. This was it was not done. What can be done? Yes. This intra-court appeal is filed against an order. You have sought a direction to fill up the vacancy with BC. We therefore do not find it. Yes. Huh?
Time was granted.
Huh? Bell rang. So one case you can call, no? Who knows, it may be infructuous. Huh?
Yes, what do you want?
No, nothing. He said. Obliged, no? Fine, order has been passed. Your name will come in the order sheet, not in the court list. Yes. Next. No, don't worry. We will not sit till 5:30 today. Don't worry.
Give for the respondent, Your Lordship. It's a batch of 7 writ appeals, Your Lordship. Only 1 writ appeal is listed, Your Lordship. May tag it along, Your Lordship.
What is the petition?
I am for the appellant writ petition. In the writ appeal, sir, senior counsel is appearing, my lord.
Huh?
Other senior counsel is appearing, my lord. Other
Pass down 6 writ appeal numbers, Your Lordship.
Along with WA number. She will give the numbers, right? Please. 120.
In fact, the petition, I am for the appellant. The petition is asking to regularize the unauthorized occupation, which is land of the municipality, which is in the unauthorized occupation. Which is in the unauthorized occupation of the writ petitioner. But the 11th single judgment directed the municipal corporation to regularize the land. And in fact, this is covered by the judgment of the some non-pro. But a similar issue, but came up before the
covered in your favor.
In my favor.
Other side is not. Let it be up.
Yes.
Give it to him so that